Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Nine out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police service club.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
All right, good morning, welcome. Welcome to the Court of Public Opinion. I'm tiny. I'm tiny this morning. I need to embiggen. Hold tight. Hold, please. Oh, yeah. Okay, here we go. That's better. Good morning, welcome. I am the Recovery Addict. It's great to have you here. We are getting set to go to court. In the Linda Stermer trial. Hey, thank you. Hold on a second. We have to do the birthdays right away. I apologize. So, first of all, Britta Aller. Britta, congratulations. You're first in chat. The internet is all yours. You've done it before, so I'm not going to give you this spiel. Just keep it running. We'll be happy. We won't complain, but we will call you if we have a problem. Okay, hold on. Hold, please. They're still off the record. Okay. Oh, my goodness. Okay, we're going to go straight to court after we sing Happy Birthday.
Happy birthday.
Yes.
You look good.
Yes. Okay, so do we have any birthdays today?
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I was going for a 10 out of 10. How did I? 15 out of 10. 20 out of 20. Yes, yogurt. I won't hit it. Thank you. I've got dinner or breakfast. Okay. I've got thumbs up. All my kids lined up. The whole doorway lined up. Stick your hands in here so that they know that you're actually doing it. Look this way. Look right here. Hang on. Stick your hands in so we can see. How many thumbs up did we get? More thumbs. 1, 2, 3, 4. This is my scoring system. That's how I did. Okay, thank you. Thank you very much. I got a lot of thumbs up this morning. All right, welcome to Wednesday. Yeah, that snuck up on us. We're halfway through the work week. Oh, and I just disappeared. And I'm back again. All right, we're going to keep... we need to sing right away because court's beginning. Do we have any birthdays? There we go. Josh has a birthday. Okay, here we go.
Because he's the guy.
Oh, they're speaking to a juror. Okay, we're good. We've got time. They're calling a juror in. All right, hold on 1 second. Let's sing. Everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice to the neighbors, warm up with me if you will. La 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 la. Okay, we're gonna sing to Ayden today. Happy birthday to you. Happy birthday to you. Happy birthday, dear Ayden. Happy birthday to you. We have one more. We have Diane as well. So we're doing verse 2 for Diane. And then I don't think we get to the drum solo because look, this is happening. Happy birthday to you. Happy birthday to you. Happy birthday, dear Diane. Happy birthday to you. Ayden and Diane, happy birthday. My mic is super hot. I'm sorry. It was hot for hump day too, so most of you should be deaf. Oh, one more. We've got Eddie. Oh my goodness. One more verse. This is the a cappella one. This is after the interlude. Some of you started singing. That was my fault because I told you to sing. But last one for Eddie here, and then we're going to be done. Here we go. Everyone sing along because it's sort of a cappella. Happy birthday to you. Happy birthday to you. Happy birthday, dear Eddie. Happy birthday to you. All right, now we've got it. Now we've got everybody. Happy birthday to everyone who has celebrated the birthday today. I realize there are a million places you could have been, with, people you could have been with, but you've chosen to be here. The privilege, pleasure, the honor is ours. Hopefully we can turn that to you, make your day a little more special, or help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. There we go. Happy birthday, Caden, Diane, and Eddie. Oh, we did make it to the drum solo. Everyone grab your drumsticks. We're going to finish this off properly. Oh, happy birthday, Mary. Happy birthday to you. Happy birthday, dear Mary. Happy birthday to you. There you go. Mary, happy birthday. You guys, I'm not jumping on you because it's your birthday and all, but you got to let us know sooner. You got to let us know. There's a form. You can fill it out a year in advance. You can fill it out 364 days in advance if you need to. That way we can get it right. So good job. All right, where are we at this morning? Well, we have a juror issue. We don't know what it is. But the judge said to all the media in the courtroom, please shut off your cameras. We need to talk. Shut off your audio. We need to talk to a juror. So we are talking to a juror. What do we talk to jurors about? Let's just go over this in our head. What do we talk to jurors about when we are in court? A problem. Yep, that's it. It's pretty much just a problem. The jurors talk to us when they have questions, but when we talk to the jurors, there's a problem. The problem could be a couple things. The problem could have been, I have a problem with my work. My boss says if I don't come back tomorrow, he's going to fire me. Well, that's the boss's problem. It's not the juror's problem because the judge will let them know what the law is. The next problem is I have an emergency. I just remembered my wife's having a baby tomorrow. I can't be here. Sad oversight on the part of the juror. If that's the case, I would just use that as an example of something you might forget about. You shouldn't, but you might. That would be like, okay, now we need to excuse you, and we'll bring in the alternate. Let's see, what else? I'm having myself a situation of sorts. It could be financial, it could be medical, it could be personal, it could be mental, whatever it is. I'm having a situation that has made me no longer fit to serve as a juror. All right, we're going to have to release you. We're going to bring in an alternate. It could be number 4, which we never like. Number 4 is, Judge, I don't know who to tell about this, but something happened about this case outside of court, and I thought you should know about it. That's the problem one. Because that's the one that could affect the case, not just the jurors who just deliberated on it. So there are some alternates. Whatever's happening here, if we find out about it, well, then we'll find out about it. But if he's like, look, all the other jurors are good about talking about this right now, and I just don't want to. I mean, they've been deliberating for days. That would be an issue, right? That would be the sort of thing. It's like, well, now we have a mistrial. So I don't know. We can speculate in our minds about what has happened, but all we know right now is that they need to talk to a juror about something, and maybe the juror will continue to serve. Maybe it's not an issue. Maybe the juror's like, hey, I just realized you just called a witness to the stand that I saw at a family reunion, and I'm like, wow, I forgot that he was my uncle. Yeah, now what? It could be something like that. There is crazy stuff that's happened in court, and it will continue to happen. They lost a second juror on the Lori Vallow case. Oh my goodness! Oh, they're never gonna make it through. They will never make it through. Yes, objection. RA is speculating. Judge, can I get a ruling, please? Yes, I am entirely speculating. I'm just saying these are the types of things that we have seen from jurors. We've seen somebody contacted me. We've seen I overheard something. We've seen my boss says I can't serve anymore. We've seen I'm feeling ill, I got sick, or I don't want to sit next to somebody who is sick. We've seen all these excuses. Only 2 alternates left in Vallow. They're dropping like flies. I tell you, it's just pretty soon it's just going to be mistrial. That's the worst kind of mistrial. Because you do everything. Good thing it's your channel. Speculate all you want. Thank you. I appreciate the permission. I will continue to do so. I'm happy. I'm happy today. Mostly I'm happy just because we're here. We're together. We're watching court again, and I love it. And it's a hump day. It's a hump day. They almost lost a 3rd juror. Oh, almost. Okay. When you almost lose a juror, I think you're going to end up losing that juror, because then you're like, that's when you're on the full count in the baseball term. Okay, you've got 3 balls and 2 strikes. The next, if the juror doesn't hit a home run or a base hit in the next pitch, he's gone. He's gone. Just saying. I fooled you with a fake court hearing yesterday. We did, just at the end of the day. It was fun. All right. A juror was using their phone during testimony. Whoa. 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 What part of instructions don't you understand? Please tell me they weren't live tweeting. Oh. And then asked a question. Angela. Oh, my goodness. A juror. Let me Google that really quick. Even worse, ChatGPT this. What questions should I ask if I'm a juror in the Lori Vallow Daybell case in Arizona right now? ? Send. Yeah, that would be terrible. Terrible. Please tell me that was the one we lost, not the one that we almost lost. Because if we didn't lose that one, that we have a problem. He was responding to his daughter. He's like, how's the case going? So is she guilty yet? Were they using their phones for notes? Oh, man. We're close. We're close. I'm close to my daughter. She's got a phone. I've got a phone. She's got my number. I've got hers. And we talk all the time, Judge. You should have known this. If you want me as a juror, you get the texting version of me. Yeah, we haven't had a good train wreck trial in a while, and I figured that's going to be the one. Only reprimanded, he stayed. Drag the daughter. How could the daughter not? I'm sure if they text so often that he feels it's appropriate to text her during court, she probably knows he's on the jury, right? And I'm thinking, the juror said he was texting his daughter to wake her up. No. Good morning, honey. We're in break now. Well, we'll be in break now in a minute. Catch you later. You should be out of bed now. Make sure you eat your... Speaking of breakfast, I'm sorry I brought my breakfast. I'm going to eat it while the judge talks.
Please be seated.
Counsel, we're back on the record in the case of People versus Linda Stermer. Any matters to address before we bring in the jury?
Your Honor, Mr. Miller just had to run downstairs. I thought he'd be back, but if we could just wait just a few minutes, I'm sure he'll be coming in the door in just a few seconds.
Okay, thank you.
Thank you, Your Honor.
Bursting through the door.
Yeah. I think he just forgot something.
Don't forget something when you go to court, especially if you're the prosecutor. It's a bad look.
So, so counsel, on the sweatpant instruction, is this the final, the one you sent, Jay?
Yep. Wolf and I wrote that together, Your Honor.
Oh, co-authored. They co-authored.
I'm sure it's only 2 sentences.
It took us 10 minutes to fashion it.
Okay, the sweatpants you'll see in the video are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. That's it? Okay. And you'll alert me when it's time to give that instruction, Mr. Mueller or Mr. Blair?
Yes.
Okay. Okay, we'll bring in the jury then.
Sure, she waits till I take a bite of granola and yogurt to bring in the jury. I thought it was safe. All right. The other Jewel says, I watched a recap of Lori Vallow Daybell trial, and her cross was brutal. Such pointless questions to first responder, like, did you drive? Where did you clean up after tending to the victim? The sweatpants instruction. Let me call Mrs. Ari really quickly. I need to see if I can borrow any of her. She has any polyester sweatpants.
And Mr. Mueller, I think you had your witness on the stand.
Thank you. I'm recalling Robert Trinkle.
The judge has the streaming beams of sunshine illuminating her hair, which looks luxurious this morning.
Morning. Sir, before you have a seat, I'll let you put your bag down, but before you have a seat, I'll swear you in again. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please
You're
have
going
a seat.
to see what the importance of the sweatpants is in just a
And
moment.
Mr. Mueller, you may continue.
Thank you. Good morning, ladies and gentlemen.
You sat on the evidence. He just sat on the evidence.
One more thing.
What is the witness placing all over the bench? I see a bunch of binders coming out. What are those?
They have information, Mr. Leroy's photographs, things of that nature to refer to when I testify.
I would prefer, well, if they're going to be, are they admitted exhibits? I mean, we need to rely on either what's been admitted or...
Your Honor,
I understand that. I'm just kind of throwing that out there so we're all in.
Okay.
He brought his whole office with him. And if anything he looks into...
Sir, you can leave them out for now, and we'll deal with it. If there's issues along the way, we'll deal with them as they come up.
I see Deer Park water.
may I begin? Thank you.
If he opens them, prosecution
Mr.
can look at
Trinkle,
him.
yesterday we were talking about the scientific method at the end of the day. You remember that?
Yes.
And the steps you have to follow.
Yes.
And the consequences of if you don't follow those steps. You remember that?
Yes.
There's something that Mr. Leroy had testified to regarding a book called NFPA 921. Can you tell us what that is and what significance that book, that guide, has in the fire origin and cause industry?
NFPA 921 is listed as a guide for fire and explosion investigations on the front cover. It was first printed in 1992. The most current print is 2024. And it's a book that assists in how procedures in fire investigation, many of the other variables but that relate to and the periphery of fire investigation and direct fire investigation.
Okay. In a kind of a nutshell, does it give you the do's and don'ts of when you're doing a fire investigation?
That would be a good way of putting it. Yes.
Is that something that you've been trained on and fire investigators are trained on in the course of their careers?
Since 1992, I used that book as one of my texts when I taught in the college level at Medina University, a basic and advanced class. I used that book in Kirk's Fire Investigations as supplement.
Is NFPA 921 considered in the industry kind of the golden standard of the guidebook of how you train?
Yes, on the front of the book it says it's an ANSI approved document. It used to say it was an ANSI standard, American National Standards Institute standard, but a standard has to be in the form of shall, will, and must. It's codes when I enforced codes in the fire inspection and fire department in Detroit. All the codes had to be met specifically. This can't be met specifically because there's too many other materials to cover, but NFPA 1033 is a standard, and it refers to this book as the book to follow.
Okay. I want to, as we now talk about your role in this case and what you did, I want to introduce subject matters, and you tell me if NFPA 921 guide you in those areas. I first want to talk about Mr. Leroy's excavation. Does NFPA 921 provide guidance in the importance of excavation?
Yes, it does.
And let me show you something.
Kurt, welcome. Good to have you here.
Is this a section 18.3.2.3 that discusses excavation and its importance?
Yes, it does.
Your Honor, I guess, are we admitting these as an exhibit?
No.
Since we're displaying them to the jury? Or what?
Again, under 707, it's a learned treatise that Mr. Leroy talked about, and it's used for impeachment of Mr. Leroy because it gives the guidelines that he didn't follow.
That's improper impeachment.
Thank you. It's not going back as an exhibit. So let's talk about
maybe that's
what
proper.
This section says. Oops.
Oh, we highlighted the blank area. Check is hard. Oh,
These
that's
times
even better. It's
pen.
getting smaller. Third time's the charm. There you go.
Adequate debris removal is essential for a thorough fire investigation.
He messed up.
You agree with that?
Absolutely.
Why?
Why? Because if you don't do adequate debris removal, there's no way you can articulate the exact cause of the fire without clearing everything and making sure there isn't something else that you didn't uncover that could have been a cause.
Okay. Next part says, one of these times, there we go. Inadequate removal of debris and the resultant exposure of limited portions of fire patterns and other evidence may lead to an incorrect analysis. Do you agree with that?
Yes, I do.
That is everybody taught that?
Yes.
That would include Mr. Leroy.
I don't know what training he actually has. He should have had that, yes.
Okay. And then finally, a fire scene investigation normally involves dirty and strenuous work. Acceptance of this fact is essential in conducting a proper fire investigation. Do you agree with that?
That's the Mike Rowe clause.
Okay.
Dirty jobs. Fire investigator.
You saw what Mr. Leroy said about how he excavated and his attempt to collect data.
Yes.
Does NFPA 921 speak to that?
Yes.
All the large print.
Avoiding presumption. Does NFPA, when we talk about avoiding, what happened? When we talk about avoiding presumption, it says no specific hypothesis can be reasonably formed or tested until some data have been collected, right?
Correct.
Because how does that tie into the scientific method?
Well, scientific method says that you have to collect data, analyze the data, test your data, and formulate hypotheses. If you don't have all the data, how can you possibly do that?
Okay. And the second section, all hypotheses should be subject to rigorous testing through the scientific method. What do you understand to be rigorous testing?
Rigorous testing is, if you can, try to recreate what you believe happened and do it with physical evidence, deductive reasoning, recreate. So sometimes you can't, for sure. But if there's something that you can do, you want to make sure that you do everything you can to establish that it is right or wrong. You try to disprove whatever you believed it to happen. If you can't disprove that, and you have all these other potential hypotheses, if you can disprove, you can eliminate many of them and only have one you can't disprove, then you actually have a cause. But if you have more than one, you can't.
You heard Mr. Leroy testify. You sat in on his testimony, right?
I did.
And you actually read his transcript from his testimony.
I did.
All right. You heard him say you're trying to prove and disprove a hypothesis. Do you agree with that?
No.
Why not?
Well, simply because how can you prove and disprove to start with? You can't do both. If you do both in the same particular scenario, you're trying to collect data and analyze and come to a hypothesis. The idea is if you can't disprove it, then that must be a valid hypothesis.
And NFPA 921 speaks to whether trying to disprove or prove in the scientific method.
I can make him louder,
yes,
but it's going to make the prosecutor a little louder too. Take a little.
Is this the section you're referring to? 19.6.4. When testing a hypothesis, the investigator should attempt to disprove rather than confirm the hypothesis.
That's correct.
Right. And as we were talking about documentation and the importance of documentation, does NFPA 921 speak to that?
It does.
16.1.2.
Yes.
Thorough and accurate documentation of the investigation is critical because compilation of factual data is necessary to support and verify investigative opinions and conclusions. How does that affect you in your role? You come in 15 years after a fire inspection, the evidence isn't there, the house isn't there anymore. What's the importance of documentation to you?
Well, it also says in NFPA 921 that when you conduct a fire scene investigation, you have to be able to preserve that investigation, whether you call somebody in before you do any movement and have that other person come in and look at it with you, or you photograph, videograph, diagram, and preserve it as you went along. Like, for example, to do the excavation of debris. You don't just take one picture before you move it and then one picture after. It's an archaeological dig, and you need to document and preserve every aspect of that. Every piece of evidence you find, whether it's of value or not, you have to record it so somebody else can take that same information and they evaluate it.
Okay. Now let's talk about what Mr. Leroy saw at his inspection. Do you recall, this is photograph 62 from Mr. Leroy's photographs. This is what would have been the basement that he said the first floor dropped into?
Yes.
Okay. And can you see the remnants of a basement fireplace?
I'm going to grab the pictures that correspond to that. I'm sorry for having to do this, but my eyesight's pretty good, but what I see in this picture is the
it's a yes/no question.
some of
Can you see
the flue vents for the chimney chases.
That would be
I think that yes, and I think that is the fireplace right behind it.
And right here where I'm pointing, would that be the fireplace?
That's the fireplace for the basement.
In the
yes.
basement?
Yes. Okay.
Okay, so this is the 2 feet of rubble he was talking about throughout. Do you remember how big he said the living room was?
Yes.
About the size of this whole area of the courtroom?
Yes.
Right.
I was at the scene, but there was nothing there. You know, I went there years later, so I know the dimensions, and I couldn't pinpoint obviously where a living room or any other rooms were, but I agree with that's approximately what it was, and we had diagrams to show that too.
Okay. And then you've seen Mr. McHugh's photographs that we showed?
I did.
I'm going to show you. Mr. McHugh had said was the amount of excavation that, or documents of the living room. Again, that's all the rubble that was down there?
Yes.
Did you have any, and do you remember when Mr. McHugh got there?
He was there on a day or so after the fire, I believe.
2 days?
10th, maybe, 11th.
Okay.
These are terrible pictures.
Well, actually, it's on his pictures.
And you
Clear
saw
twice.
Mr. Shinsky's photographs, correct?
Yes.
That would be the rear of the house after Mr. Leroy had been there
Yes.
and told us that he excavated a big pile that was 7 feet high. You remember that?
Yes.
Okay. This is Mr. Shinsky's photograph. Did that play a factor into whether or not Mr. Leroy actually did what he said he did?
Well, it certainly confirmed he didn't. There was debris that he removed. He removed, obviously, the vent pipes that were central to that area, that space. And he also moved remnants of furniture, springs, and some debris. But even after that, yes, that's some of the, I think there's a vent, or the cap, and a few other things from one of the flues. There were triple flue there. There was one for the furnace, one each for the fireplaces. So there was a lot of piping there, and he removed some of it. But there are photographs that show after that there was still a bunch of debris, or that pictures that he even took himself to show there was a pile of debris still there.
I want to discuss some of Mr. Shinsky's photographs. Mr. Shinsky's, you reviewed his excavation and his photographs?
I did.
Does it comport more with what 921 calls for in terms of how you actually excavate something?
Yes.
All right, let me, if I can, Your Honor, we've admitted as Exhibit I the photographs of Mr. Shinsky. I'd just like to publish them as we go along.
They've tried to lay the foundation to say that the other fire investigator did a shoddy job and didn't clean up enough trash to get down to the facts of the fire to be able to ascertain the cause and origin. But they're looking at the basement, where it's, I think even this fire investigator will have to admit that the fire did not start in the basement. And
I know I brought enough for the whole class last week. I hope I have enough for the whole class this week.
Your Honor, can we please stop with the commentary?
I'm not sure if they're handing out treats or if everyone gets a paper here.
This first photograph, what does this depict to you compared to what it would have been when Mr. Leroy left the place?
Well, this one certainly shows that they had an excavator or some mechanical equipment to help. But they take the walls down, and you can see them laying around the outside perimeter of the house. Twofold, one for safety, and the other to examine what the remains were. How sometimes they call it, if you just do it on a piece of paper, a blowout diagram. You put the walls on each side where you could, what's remaining, and you mark those as, wall north, south, and west, and east, and then show what's on the interior. It's for safety. It's for safety.
Let's talk about the second photograph. Does that show more of Mr. Shinsky and what he was doing in terms of taking the walls down?
Yes, it's a closer view, and now you see people inside where they now can feel safe. There's something not going to fall on them.
I'm showing you what was marked as Exhibit O floor plan of the first floor, we can kind of get a reference. Do you see this back area? We'll talk about it more on other pictures. You see that back area that's cleared out?
Yes.
Does that correspond to where the bay window would have been?
From this angle, that's pretty much the best you can get, but yes, it's in the northwest corner of that room that you circled. That's probably better, yes.
Okay. And this is just more of an excavation as it's supposed to be done?
Yes. There's still debris on the floor within that room that Mr. Leroy is supposed to have
I'm on
excavated.
photograph number 5, and they're Bates numbered. We can see this excavator up at the top.
Yes.
Is an excavator appropriate for an excavation?
Yes, there's a variety of ways that you've got to be careful about using them, but absolutely.
Okay. As you look at the photograph on 5, can you see this man who's on the right over here?
I do.
All right, the area behind him, would that represent the living room?
Yes, that's the area. That's the area that we're speaking of. That's in the darker color.
All right. So the bay window that's at the bottom would have already been knocked out by the excavators.
Yes.
Right. So this represents the rubble on the first floor, which would have been the living room as it fell into the basement.
Yes.
All right. And do you remember what Mr. Leroy said about how he cleared out the basement?
He said he said he did it, but obviously he didn't.
Okay. Photograph 10 is just a photograph of what?
That's the electrical distribution panel that's obviously been involved in a fire with wires down below it that are bare copper conductors that have burned off.
Okay. Is that something you have to consider? We'll talk about it more in detail, but is that something you have to consider in terms of trying to find out what happened in the fire, what caused the fire?
Your Honor, can we approach?
State's not liking how this one's going. I do remember the original fire investigator saying he cleared off a specific area, basically down like completely, right? But the problem we have here is we now have evidence that an excavator has been brought in, and we know that a window has been knocked in. And now he's saying, now you can see in this picture that there is stuff still in the family room area underneath. So it's obvious he didn't clear it down to the ground level, down to the floor. In time, that doesn't add up, because it could have been cleared to ground level. Then the bay window, that wall gets pushed in, and now there's debris again. Yeah, there may have been a fire. I'm looking at the picture. I'm not a fire investigator, but I'm pretty sure something in the house was really hot, at least. That's what I've been able to ascertain. Judge is trying to understand. Defense is arguing something, which means the judge probably has a question for the defense. Which makes the ruling.
I then want to talk to you about some of the photographs. This is 13 from Mr. Shinsky's photographs of the 15th. What does that show you?
Moved on.
That shows some of the debris that was removed, more than likely 75% by excavator and placed according.
How do you know that?
Is the number 75% by excavator? I don't think he's capable of saying that, Your Honor.
These are heavy pieces of evidence. A human being couldn't do it. He's been on thousands of excavations. Thousands. Thank you.
And others were moved by hand, the smaller objects.
Okay.
But in a placement such as they can look at them and define where they may have been and try to see what they may or may not have to do with the relationship of fire cause or not only fire cause, but fire load.
More evidence of what?
Examining pieces of the appliance here to look at it to see if it could be ascertained whether there were something to do with the cause or just affected by the fire.
And in terms of laying it out and looking at the pieces individually, what step to the scientific method does that go to?
That would be, finding the evidence and then looking at it. You're collecting the data, which is that's some of the data, and then you're analyzing that data by putting it out and checking to see if you can make a hypothesis about each and every one of these pieces of equipment.
Okay. This last picture, 17. What does this show you in terms of how one excavates and the proper way to do something?
The investigator is isolating, for example, in this case, the flue pipes, laying them out in, I won't say in order, laying them out and seeing if they can determine a potential order, but as I said, there's 3 chimney chases, and you try to match up oxidation, different things on the flue pipes to see if you can match them all up, but some were smashed as a result of the collapse of the building. And then you've got other appliances again, furniture, that is examined and trying to determine what value they have, as I said, either cause, origin, or fire load.
In terms of fires, obviously every fire can be different. Big fires, small fires, dumpsters, whatever, right?
Right, they're all uniquely different, sometimes to a great degree and sometimes to a small degree.
Are there occasions, or frequent occasions, where the damage is just too much, where you have what's called a total burn?
Well, total burn is, like the word says, total, but a burn that is very extensive with collapse of floors, roofs, and all that is a very difficult investigation.
And why is that?
Because much of the items that have been consumed in the fire, much of it is because there is such a wide area that you can't even find the origin.
Does NFPA speak to that, NFPA 921?
It does.
Well, I'll show you this section, 18.8. Is that what you're talking about?
That's the one I have right in front of me, yes.
Yes?
Yes.
All right. What that document says is a conclusion of the origin investigation can be the identification of a volume of space too large to identify causal factors or no practical boundaries can be established around the volume of the origin, right?
Correct.
All you folks are taught that?
Yes.
You tested things like that?
Yes.
And I'm sure you've taught it to firefighters?
Yes.
Okay. In this particular case, Mr. Leroy defines an area of origin, as we had talked about 20 feet by 20 feet. Is that, in your opinion, a reasonable area of origin?
It is not.
Why not?
Because, as this section says in practical experience, the book talks about an area of origin and a point of origin. Sometimes you actually do have a point of origin, but most of the time you do have an area. But that area consists of a very much smaller diameter or perimeter.
Give us an example.
Fire starts in a living room. It consumes many of the contents in the living room, flashes over, but by examination of each piece of the evidence there, you can get down to maybe a sofa where somebody was carelessly smoking, or a lightweight electrical cord on the floor that may have been the cause of the fire. But you have to do that, as it says, painstakingly, hard and dirty.
Okay. Is there any sense of embarrassment if you say the area is too big, the damage is too much, I have to say it's undetermined where the fire started.
No.
Let's talk about the area of origin as one, the living room, and then two, you've reviewed Mr. Leroy's work. Did he adequately consider alternate hypotheses in terms of the area of origin?
He did.
Okay. Why not?
He said he
I'm
did.
sorry, maybe I misunderstood the question.
Yes, did he adequately consider anything else other than the living room?
He didn't adequately, but he did consider other hypotheses.
Okay. Did you, as you looked at the file, see other areas of plausible origins of the fire?
I do.
Give me an example of one.
The most reasonable one is the fire in the chimney chase.
And we'll talk about that
I think we're talking about cause, not area of origin.
No, we're talking about the area of origin of a fire in the chimney chase.
It allows examination.
You have to get, thank you. Do you have to get to origin before you can get to a cause?
Yes.
Why?
Because if you have the wrong origin, you couldn't possibly have the right cause.
Okay. In terms of analyzing the chimney chase, what did you look at?
I looked at photographs and actually Mr. Leroy's trial testimony in this case, where he said everything I would have said to say the chimney chase is the most probable cause or possible cause. I won't say that. He had information that he said exactly like I would have said to say this is something that we have to consider.
Okay. Did you look at, for example, photographs of how the fire was spreading from the in-car video?
Yes.
And witness statements?
Yes.
From the on-scene folks?
Yes.
All right. I'm going to show you.
I thought the in-car video was lost.
Prosecution's photographs from the in-car video, and what does that describe to you in looking at the house?
That's from a dash cam from one of the responding sheriff's officers, and the fire is in the back of the house, burning in the upper portions, and the smoke's coming out from that back central section.
Okay. Do you remember witness statements saying they saw flames coming through the roof?
Yes.
Okay. Would that be consistent with the chimney chase fire?
Yes.
Okay. Did you also look at Mr. Leroy's pictures?
I did.
I'm going to show you a photograph, and you tell me if that helps give you evidence or data to consider in a chimney chase fire as another point of origin or area of origin.
Yes.
You tell me what we're looking at and where you want me to point.
If you can point toward the second or the first floor fireplace, which is almost dead central in the picture. Right
Here?
there. Yes.
I'll back that up. Go ahead.
Okay. The roof is collapsed behind there, behind the chimney, and there's almost nothing else left behind the fireplace where the chimney chase would be.
Tell us, what is a chimney chase?
Chimney chase is a facade that goes around the flue vents, and it's supposed to be a certain distance away from the flue vents. There's not supposed to be anything in direct contact, but that's what's directly behind that the chimney. In that opening where you've got the header and the vertical 2x4s, where Mr. Leroy said, well, that was proof that there was no fire in the fireplace. That really would have had nothing to do with it, because that is a protected area, and there would be no way that it wouldn't burn if everything else burned, except it was protected and it was insulated, and it was what held that fireplace in check. But I don't believe there was a fireplace fire. I believe if there was anything, it was in the chase, and nothing else above here except minuscule amount of rubble, and the chimney or the roof failed at that point, which is a good point of reference to find out where something happened.
What causes a chimney chase fire?
A variety of things. The flue vents now are circular. They're not just old brick and stuff like they used to be in
So you saw the aluminum flues.
Yeah, they're not aluminum, but steel.
Steel.
Yeah, stainless steel usually. Some are just plain old.
So what can cause a fire to happen in a chimney chase?
All right, two
with
things.
A flue?
One would be having insulation directly in contact with it. I've had two fires. Actually, one was one way, one was the other, just within a couple months apart, a couple of years ago. One, because they were putting blown-in insulation in the roof area, and they were supposed to protect the area with a chimney chase, and they didn't. So while they were doing the insulation, it fell into the chase and was in direct contact. So over time, the insulation materials caught on fire, which caught the chase on fire, which caused the house to burn. But it wasn't nearly as bad as this. I mean, it was very clear that that was the cause. The other cause was the result of these flue vents are 4 feet long or 3, whatever the distance is. I think usually 4 feet. Those look shorter to me in the picture, but they are connected. You twist and connect until you get up to the top, and then you put a cap on the top of that.
And that's why it's laid out to analyze whether that could be a cause?
Yes.
But you have a lot of damage to those.
Right. They're too damaged to be, like say, some were, the ones that Leroy took out, some of them were actually almost flattened. I think he even mentioned that in his report or in his testimony. And those you wouldn't be able to tell. But in the other instance, the chimney came down in whole. The whole thing was on the side of the house, and everything, what remains of the chase and the flue came down, so we were able to put it all together. And there was a gap where one was
Objection, Your Honor. He's never held any of this evidence. He can't talk about putting things together. How is he testifying to this?
Your Honor, he's an expert who's done thousands of investigations, and including chimney fires, and he's talking about how you go about analyzing the evidence, the data. This is part of the scientific method.
But he's talking about, we put this together. He's never touched any of this. How is he testifying?
I'll allow him to re-answer the question. I didn't hear what you heard, Mr. Blair.
I heard it.
Thank you.
Miller?
Now, I want to show you, Mr. Trinkle?
Yes.
I want to show you Mr. Leroy's photographs, his own photograph of what he took out of the house.
Yes.
Is this the piece that you're talking about that was flattened?
It may be. I'm sure there were more than one, but yeah.
And does this look like how a proper excavation would lay out evidence?
No.
So do you have an opinion of whether you can rule out a chimney fire, a chimney chase, as being the area of origin?
Yes.
What is that opinion?
You cannot.
And what does that say in terms of Mr. Leroy's conclusions as far as your ability to have confidence in them?
You can't have any confidence in them, but I was amazed when I heard him say, and then it's in his, in the transcript, that he explained everything I just explained, basically, and how that could happen.
And then ruled it out with what? Any analysis?
He said it wasn't low enough. I think, that might be misquoting, but it was up high, and he explained how the fire would travel upward in the chase from wherever the fault was. But he doesn't know where that fault was, nor do I.
If you had a chimney chase fire, could it explain a sudden burst of flame?
Absolutely.
How?
Well, the chimney chase is confined. It's burning what's inside, but it's eroding the OSB or whatever, siding they had on that chase, and it's going to eventually go to the other areas. That's where you see the whole house is burned down away in the backside of that where the chimney chase was.
Okay. Now let's talk about Mr. Leroy's opinions of causation, how the fire started. Does NFPA 921 give us guidance on that?
Yes.
I showed this to Mr. Leroy. The cause factors for a fire.
19.1.1?
Correct.
Okay.
The determination of a fire cause requires the identification of those factors that were necessary for the fire to have occurred. Those factors include the presence of a competent ignition source.
Your Honor, I'm going to object. I think he can maybe ask the witness to talk about it, but he's literally testifying from the book.
I'm not testifying, I'm just reading what this says.
It is getting to the point of testimony, so perhaps rephrase the question.
Tell us what 3 factors are necessary, required, to have a fire cause.
Certainly the competent ignition source, the type and fuel first ignited, and what brought them together.
Okay. Does it also speak, NFPA 921, as to whether or not you can get away with less than all 3?
It says you can't.
19.4.4.1, does that speak to that?
Yes.
Can you read that?
I can, particularly it's in front of me. Even though I don't need glasses yet, it helps.
Can you read that to us?
It says simply identifying a fuel or ignition source by itself does not and cannot describe how a fire came to be.
In other words, 1 and 2 by themselves don't count.
No.
We're going to talk about how Mr. Leroy got to his open flame and gasoline issues, but do you remember him testifying about number 3, step 3?
Yes.
And how he couldn't identify how the fire 1 and 2 got together?
I do recall that, yes.
Okay. So what does that mean in terms of being able to identify how the fire started, the cause?
It means he can't, and he didn't.
What does that tell you in terms of your confidence in his opinion that he actually identified a cause of the fire?
Well, I guess if I put a percentage on it, it'd be 0.
Let's talk about Mr. Leroy's identification of the origin and being in the living room, but how he used Ms. Stermer's testimony to help solidify that basis. You remember him talking about that?
Yes.
Sorry, I'm doing some editing on
What's the one thing that you found consistent in every one of Linda Stermer's statements?
She was downstairs, he was upstairs, or her husband was upstairs.
And then what happened?
She heard a sound, a scream, and ran from the basement upstairs and saw that the fire was in the living room.
Do you recall whether he agreed with me that you can't be in 2 places at one time?
He did.
And what does that tell us about Linda Stermer being in the place where Mr. Leroy thought the fire started at the time the fire started?
Well, we tell you that there's no way she could have been involved in setting a fire.
Objection, speculation, Your Honor.
Mr. Blair, could you please bring the emotion down?
Sorry, Your Honor.
Thank you.
That caught me off.
You have you have an objection, and what is your objection?
Speculating as to whether or not the defendant could have started the fire. You can't be
testifying that she wasn't in the same place as Todd Stermer when the fire started.
I'm going to sustain that objection.
Okay. Do you recall Mr. Leroy agreeing with me you can't be in 2 places at one time?
Yes.
And that Mr. Stermer was by himself when he got caught on fire?
Yes.
Okay. Let's do a hypothesis. Here's a hypothesis. Linda Stermer was upstairs with Todd Stermer when the fire started. Do you have evidence that would support that or disagree with that?
Evidence to support it.
You have evidence that Linda Stermer was in the basement?
Yes.
So you can rule out the hypothesis that she was upstairs when the fire started?
Yes.
Right?
He said the wrong thing.
That's according to the data that you have, and that's the only consistent data you have, right?
Yes.
Do you remember that Mr. Leroy found that evidence to be reliable?
I do recall he did.
They might open the door here. They might open the door to the red towels. Oh, it might open the door. What evidence do you have?
In terms of alternate theories, alternate hypotheses, is that important that you have to consider different theories?
Absolutely important.
Why?
If you don't consider all of the other potential theories, then you can't come and render an opinion that there's one and only one reason for this fire to have occurred.
Let's talk about this idea of gasoline on the sweatpants. And first of all, why don't we do this? Let's talk about fire propagation. Can you tell us what factors are involved in fire propagation? Because you understood that one of the things Mr. Leroy talked about was this was a fast fire.
Yes, I believe that definitions of different kinds of fires would be a friendly fire, a hostile fire. Friendly fires don't get out of control, don't hurt anybody. We enjoy them, fireplace or campfire or cooking. So, on the other hand, when you say a hostile fire or a fast fire, that connotes that you can tell the speed of a fire by looking at it or not considering anything else.
Does 921 give guidance on whether you should be considering that? Calling things fast, abnormally fast?
It does.
Section 23.7.2 speaks to that, doesn't it?
I think it's stuck in the, excuse me. Yes.
And what does that say?
It says, what the investigator may consider as excessive, unnatural, or abnormal can only occur in an accidental, or can actually occur in an accidental fire, depending on the geometry of the space, the fuel characteristics, and the ventilation of the compartment.
Tell us a little bit about that, then I want to show a video that you made. But tell us about the factors that go into it. Compartment, fuel load, ventilation.
Okay. A fire in a accidental scenario will start, it's called the incipient stage, a very small stage of the fire. It will progress from that point and continue to progress depending on the fuel load and the ventilation.
Ventilation is very important.
Yes.
And fuel, fuel, do we think of it as maybe gas, oil, that kind of thing? Is that what fuel is considered?
Sorry, I missed that. I apologize.
To a fire investigator, what is fuel?
Fuel is anything that burns. Anything in this room, almost everything will burn. Steel, even how they make cars and things by melting steel and reforming it. But in a situation like we're normally used to, wood products, plastic products,
Hot Wheels,
cellulosic materials, and flammable and volatile materials.
And when windows burst open in a fire, does that help fuel a fire?
It does.
Why?
Because now more air and oxygen is let in.
You have a video that you made, what year?
30 years ago, I think, 1993.
And what is that intended to demonstrate?
That was intended to demonstrate, at that time, a specific fire, but it also was intended to show how a fire without any kind of fuel, like liquid potential that can ignite, ignitable liquids they call it now, was not involved.
And what's intended to talk about in terms of fire propagation?
To show how heat and smoke rise, which is natural, and the fire will continue to burn until there's no more fuel left or no more oxygen or somebody extinguishes it.
Were you considering, too, the time duration of how quickly a fire can develop with just accidental cause.
Yes, there's all kind of national and other videos that show, you know, a fire can go to flash over from a natural fire in 2 minutes, 3 minutes.
Okay. Is it intended to demonstrate principles?
Yes.
Your Honor, we move for the admission of Exhibit JJ, a demonstrative exhibit.
Mr. Blair?
Other than the limiting instruction I'm going to ask the court to give regarding this exhibit, I have no objection.
Okay, thank you. Do you want me to provide that instruction now, counsel? Okay. Jury, I have an instruction for you. This video is being admitted only to illustrate this witness's testimony. The parties agree that the video is not in any way a recreation of the events at issue in this trial. You may only consider this video to help you understand and evaluate the witness's testimony as it relates to the speed at which a fire might grow and propagate in the absence of liquid accelerants under certain conditions. Counsel
Thank you, Your Honor.
satisfied with that instruction?
That's fine.
Mr. Blair?
Yes, sir.
Okay, thank you. Yes, what?
JJ?
JJ? Court will receive Exhibit JJ into evidence.
And you can kind of describe for us as what we're seeing.
That's okay.
Yes.
Okay, right now, in that cardboard box, there's crumbled paper product. It was lit with a match. And there's nothing else to influence its growth outside of, you know, the configuration of the structure and the fuel load.
And you started at 2:04 p.m.?
You know, it says it on that one. I'm not sure the other, there are two camcorders videoing this, and I don't know if the other one says the same thing. I think it does, yes.
I've done this experiment in a fireplace with the
Switch
box.
from this camera after about a minute.
Reflected
to the
heat
camera on
is
the other side.
extremely powerful, accelerating the fire.
Jury, is this board in your way? Better? Okay, thank you.
So this is just switching the cameras.
Yeah, this camera's history. It's gone. Here we go. Get out of there. Get out of there. It's hot. Laura, we're going to have the Koberger hearing on Top Market Media today. There's a new source.
It's getting
for
hot
that.
and they're moving it back, the camera.
So I'm just lining that up. It's getting hot in here.
You were actually present at this video?
Yes.
Are you the one holding the
It's
camera?
burning a building
shakily?
inside my building. Probably not the smartest thing to do.
And you are, you said a fire expert? Got to connect 2 more cables. I'm listening. I'll be right back.
And what is this showing us right here when it hits the ceiling?
Heat and smoke, fire, go to the something that stops it from going straight up, a horizontal surface being the ceiling, and then it spreads out in all directions and continues to burn until the fuel is expended.
And this is in an enclosed space?
It's not totally enclosed. It's, as I said, I had a fire truck, and I had a fire truck, I had a way to put the fire out, but it's in a big warehouse. My office, where my office was, had a 30-foot ceiling, so this is only an 8-foot ceiling, so we're not going to let it get beyond where it should. But to answer your question, there is sufficient fuel, sufficient oxygen to keep the fire going until we extinguished it.
Would you say this is a hostile fire?
This is the speed of the fire?
Yes, and that's into 3 minutes, I think.
Right, that's only about 3 minutes into the fire?
Yes. And if everything was, all what it's going through is non-combustible, double thick drywall. So we had plenty of time to let it burn and not have to worry about it going through into the rest of my building. We had 2 hallways to make it, so we had sufficient room for it to spread, and then the last one, where the last hallway goes right out to a 16-foot overhead commercial door.
I'm sorry, if you're paying $10,000,
it's only about 4 minutes
to an investigator.
Yes.
Can we spend the $35 and get a tripod for the camera?
And there's the firefighter's got his full gear on, including a Nomex headgear and a
relevance
self-contained breathing apparatus. And when they pulled back, there was no fire anywhere near them. It was just a small fire, just to show you how convected and radiated heat transfer can give you some serious burns. So they were protected, and they got out before it got worse.
Okay. That's the end of that video. You illustrated that to show how fast fire can propagate even without any liquid accelerant or anything.
Yes.
Right. Now, you also showed us, that fire is going pretty crazy in a few minutes. You've been in plenty of fires as a firefighter. Is it as dangerous as it gets?
Yes, and that one's controlled, so everybody knew what was going to happen, and they knew there's no more fuel to ignite to hurt them. So, and they had fire hose lying right there from a fire truck. But
let me address this. When you go through your training, is it so that you know how to act in a fire where it's
yes,
you're an inferno? Yes,
it's your job to put that out no matter what. People always think you see people running away and crazy firemen running in. You have to know what you're doing to do that.
What are the things you're combating in terms of critical stress and the way the body reacts?
Well, certainly your heart's pumping more than it would normally. You're excited, and you are under a lot of stress because a lot of times we come to homes, we don't know if there's anybody in there. We always treat the fires as there is somebody there.
You've learned about critical stress factors that the body goes through?
I'm going to object, Your Honor. I think this is outside his area of expertise.
Goes through his training as a firefighter. That's why they do repetitive training.
It's getting to be medical.
No.
If you stay away from any medical opinion, it's fine.
I'm not asking for opinions. You have received training on how the body reacts in critical stress situations, right?
Yes.
And those symptoms include what?
I'm going to object, Your Honor, that he's
part of his
training. That doesn't mean he's an expert on giving an opinion to a jury about what it might be.
Maybe lay more foundation of what the training was.
Tell us where your training was, what your training was, and what kind of subject matters you covered with respect to how a body might react in critical stress situations.
Well, the first 320 hours that we had were classroom training in all aspects of fire and, as you said, what we go through as a firefighter, and to make sure we were able to cope with that.
And what are the things you're trying to cope with and fight against, which is how your training is going to help you?
Well, it's sort of like muscle memory. When you're doing what you're doing, and you do it over and over and over again, and you rely on the people you're working with to have that same feeling that you do. You know when you're going in with somebody, that we always had a thing called 2 in, 2 out, that we would go in together as a team. And if we were not coming out, both of us were not coming out. If we got out, both of us were going to get out. And so in that process, you know the things you're going to be dealing with. Back in my day, we didn't have self-contained breathing apparatuses. I shouldn't say in my day.
We just
in the
had
beginning of my
we
tenure.
just had to hold our breath.
Mr. Trenkel, with respect to critical stress symptoms, did you learn things like tunnel vision?
Yes.
Describe for us, please, the other body symptoms that you learned to prepare against with training.
Object is to relevance, Your Honor. I don't know how this is even relevant at this point.
Well, can I explain the relevance? Since he made an objection?
I think, is it relating to Ms. Stermer? Is that
Yes,
where you're going?
these folks train for critical stress. A middle-aged woman does not train for critical stress. That's how it's relevant.
We're providing facts into the record here. I'm just concerned about what's going on in front of the jury with some of these statements that are being made. But in addition, he's not an expert on critical stress. And how a layperson, he's a firefighter, he's talking about a firefighter, not how a layperson might perceive it.
It's based on his training.
Testify as to firefighters
Yes.
and their stress levels and what he's learned through his training, but
Right.
not laypersons.
I didn't ask what a layperson, I just asked what symptoms have you understood through your training that you might go through that the training would help? You said tunnel vision.
Right. Well, make sure you maintain focus for sure, what you're doing, and not panic. I'm not sure the whole program that you were wanting me to tell you, but if you can maybe clarify.
Well, have you learned that you lose your fine motor skills?
Yes.
All right, that's why people fumble with their keys in a high stressful situation.
Yes.
It's leading and now
Thank
it's outside
you.
the scope. I'll sustain.
We'll go to something here. The gas on the sweatpants we were talking about. Under the scientific method, you remember that Mr. Leroy arrived on the scene 3 hours after?
Yes.
And that Mr. Stermer was at some point outside the house?
He was.
Do you have some understanding of how Mr. Stermer got from the house to where he was initially found and then transported?
From the house to where he was initially found, no. But from the movement afterward, yes.
And the movements afterward included, first of all, Mr. Matheny putting clothes on him?
Clothing being placed on him. Mrs. Stermer was on top of him, then she allowed Mr. Matheny, or not allowed, Mr. Matheny did put a bunch of things on him, but then there was also another movement.
And that other movement involved what?
I don't know if it was the fire chief or somebody else. There was somebody to assist to lift Mr. Stermer and put him into a little boat and then move him farther away from the actual burning building because there was fear of there was a 220-gallon fuel oil tank right next to the house, and he wasn't too far from that, so they moved him away.
And as a fire origin and cause expert, you remember Mr. Leroy 3 hours later said he smelled gasoline?
Yes.
Or he smelled something fuel and it turned out to be positive gasoline on the sweatpants?
Yes.
Do you have to, as a scientific person under the scientific method, have to rule out how that gas could have gotten on the sweatpants?
Absolutely.
And one of the things you have to rule out is, do you understand?
It's sustained, it's leading.
Okay, what one of the things are in terms of the boat transfer?
Objection leading, Your Honor. You're still leading your witness.
Ask you to ask non-leading questions.
I will.
Please direct.
Sir, tell us, if you're the fire origin and cause investigator, what you need to consider in terms of the transfer going back from where Mr. Leroy found him to the house.
I would have to consider, if anything, in that transfer of movement from where he was lying to where he was put in the boat and to where his final destination was, if there was any possibility of any other potential for a gasoline or fuel oil or any other kind of ignitable liquid to have gotten on him. You would have to take the boat, and we use things sometimes like sterile gauze and things like that to get liquid and then take that into evidence and have it go to the laboratory just to check to make sure there wasn't something else. And even on the ground, I would have checked the ground he was on. People were driving back and forth and all that. I don't know what was on the ground that might have been a contaminant. So those are the things you need to think about.
What about talking to witnesses, family members?
Well, absolutely.
Did you find any evidence that Mr. Leroy did any of that?
He pretty much didn't talk to anybody.
Or wipe anything down?
No.
Am I right?
Correct.
All right. In your review of the evidence, did Mr. Leroy even consider collecting data for the boat?
According to what he testified to, he didn't even know a boat existed.
Okay, so according to the scientific method, if you don't collect the data, you can't go through all the other steps, right?
Correct.
And what does that do to your confidence level that he actually ruled out that particular alternate hypothesis?
Back to percentage 0.
Now, would you also have to consider maybe possible contamination?
Yes.
How would you consider that? And what are you talking about?
Well, we also know that Mr. Matheny placed clothing and other items on Mr. Leroy for a variety of reasons. He's pretty well naked in the ground and it's winter, in that Mr. Matheny had an occupation where he came into contact with flammable and ignitable liquids.
And what would you have to do in order to determine that maybe contamination caused it?
Well, if you were the person taking the evidence, each one should have been analyzed separately, but to compound the problem, these things were placed into the body bag together and were transported, and then each one were positive for slight residue of gasoline.
Objection. He can't testify as to what the level of residue was, Your Honor. He said slight. He can't do that.
I'll allow you to cross-examine on that point.
Thank you. You do know what the threshold that Mr. Ernst said the machine was?
Yes.
0.0005?
Correct.
4 zeros and 5.
Right.
All right. Now, one of the things that Mr. Leroy said he smelled the gas 3 hours before, do you have to consider and collect evidence about maybe what did people smell when they were the first people on the scene?
Yes, absolutely, and I think during the course of time he did find that out.
Did you see where he did not interview Mr. Matheny?
Yes, he did not.
And he didn't interview Ms. Calhoun?
He did not.
And he didn't interview Mr. Masali?
No.
All right. If they have testified in this trial that they didn't smell anything and they were the first 3 people there, would that be something you'd have to consider in terms of whether you could rule out maybe there was contamination, maybe there was something else?
That's why I talked to them.
Okay. And would you also then, well, let me ask you this. Mr. Leroy says it doesn't matter what they say. Is that appropriate?
Selective choice of who you want to interview and believe, I guess, I would say was wrong.
Okay. Does NFPA 921 speak to that in terms of confirmation bias?
Yes.
Tell us what confirmation bias is.
Confirmation bias is when you already have a preconceived idea that what happened and you want to confirm that with the evidence, and so it comes to fit your idea of what happened.
Okay. Confirmation bias described in NFPA 921, section 4.3.10. Can you read that for us?
Somehow we got things out of place. Maybe I can read it from up there. Confirmation bias occurs when the investigator relies exclusively on data that supports the hypotheses and fails to look for, ignores, or dismisses contradictory or non-supporting data.
And then it continues, does it not?
Failure to consider alternate or opposing hypotheses or prematurely discounting seemingly contradictory data without appropriate analysis can result in incorrect conclusions.
Okay.
Sorry it took me so long. Maybe I do need glasses.
Best, from the evidence that you have reviewed, does that fit into what Mr. Leroy did in terms of contradictory data?
He did not do anything to do that.
Would you say that that fits the definition of confirmation bias, what Mr. Leroy did?
Yes.
And what does that do for your confidence level in his opinion that the gasoline on the sweatpants related to the house as opposed to anything afterwards?
There is no confidence.
If there is a theory that Mr. Stermer was set on fire with gasoline, do you remember what Mr. Leroy said in terms of the evidence of any gasoline in the house?
I'm setting up Top Mark Media for Coburger.
He opined that through extrapolating the gas that was detected on his sweatpants confirmed there was gasoline inside the living room.
And what is that in terms of scientific certainty versus speculation?
All speculation.
And what is speculation in terms of an expert? Is that appropriate?
It is not.
Why not?
Sorry. Person who is doing a scientifically proper investigation is trying to disprove those different hypotheses, and there was nothing that Mr. Leroy did to show that there was an intentionally set incendiary fire.
And do you recall what he said where he admitted there's no evidence of gasoline in the house other than sweatpants on testing positive?
Yes.
Starts in half
Do you
an
have
hour.
experience, sir, in your vast career with what symptoms somebody might show if they were set on fire and inhaled gas, inhaled fire?
Not a pathologist. He cannot give this opinion.
This isn't, I asked him for his experience with being a fire and origin and cause, attending autopsies, and having experience seeing people who've been caught on fire and what symptoms they exhibited on autopsy. That is absolutely within his background. It's based on his experience.
How a person may react when set on fire, he's not capable of doing that. He's not a pathologist, John.
I'm not talking about...
He's a fire investigator, not somebody trained in human mechanics, dynamics, anything to do with pathology, how the human body, organ systems. There's just no way.
Your Honor, he has experience with autopsies, what he's observed for people in fire investigations where he has actually investigated people who have been caught on fire and inhaled fire and what that exhibits. That's based on his experience. He doesn't have to be a medical doctor. These are his observations.
I'm going to sustain the objection. I think it is outside the scope of his area of expertise.
The judge got a grunt for that one.
The gasoline on the sweatpants, we talked about that and ruling out other things. Do you have, I think you didn't give us the opinion on whether that's reliable, that gasoline on the sweatpants has anything to do with this case?
I'm objecting, Your Honor. That's been asked and answered.
That hasn't been asked and answered.
How about we stop now and take our morning break?
I want an answer to the question.
It's been asked and answered, so we can move on when we get back. Okay, jury, remember your rules. Don't discussion of the case or looking at social media or media. We'll make it about 15 minutes again.
Whoa, it's getting a little spicy. Here's what I'm seeing. Defense has a good witness, a good fire expert, okay? He's got a lot of experience. He's been a lot of places. He can talk about a lot of things. Part of the problem is he has so much experience and so many years under his belt that he wants to share it all. And he wants to share everything. And in his haste to do that, he sometimes gets lost in the question. the problem that presents for the defense is they have to sort of lead him a little bit.
Jury has left any matters to address in the break?
No, Your Honor.
No? Okay, thank you.
They've had to lead him just a teensy bit to get him to the answer they want. Now they already know what that answer is. We know that because when he gave the wrong answer, he just plowed ahead as if he had given the right one. So he's just getting lost in what answer he wants them. The defense wants it each time, and because of that, defense has to lead, and the state is objecting over and over and over. And even after objection, he still has to insert and let me just steer you a tiny bit as far as your answer goes about the boat and the transfer. That is leading, and it's objected to every single time. But if he doesn't do that, he gets this answer where either the witness has said, I'm not sure where you want me to go with this question. What system could you clarify a little bit? He's either lost, or we get these answers that just have nothing to do with the question itself. So it's a tough line that defense has to walk here, and I'm not sure how well this fire investigator is going to hold up under cross-examination, because the original fire investigator may have made mistakes, and I think he did. I mean, we know he made some. There are some things that were not documented properly as far as photographs go, but the reasoning behind where he came to the conclusion he did about the origin of the fire did sound scientifically reasonable and probable, and like it was a logical conclusion. It's a little harder for me to say that the origin of the fire was the chimney in the living room when the studs closest to that chimney were not burned. That's a tough one, and that's what this fire investigator is saying, that space, not in the fireplace but above it, between that and the ceiling, is where the fire started. But the studs in that compartment, we looked at that fire. You saw the combustible materials inside a box burning in a storage unit. It is like a chimney situation. You saw how hot, that everything in there just burned. It's hard for me to say, okay, you've got exposed 2x4s without burns on them in this image, and you're saying that's where the fire started. That's a tough one. So I'm not buying that conclusion. But we'll see. I mean, you can disagree with me, and we can still be friends. Judge sounds like she's a proponent of gentle parenting. Yes, just a little bit. I need to change one more plug here really quickly. I've got. Actually, I need to. Why is this not recording right? Put it in again, see if it works. Snap, lock. Green is good. Does not want to record. I think it just lost the network. Oh, no server detected. That's why. Oh, I know why. I unplugged it. Huh. Solved it. Okay, we'll use these instead. Do you think 265 gigabytes 256 gigabytes should be enough? Okay. Sorry, hold on one second. SDI 264. Okay, now I need to plug in something. All right, we are over on the Top Mark Media channel. We have a live stream that will be starting here in just a few moments, in about 27 minutes. That is the Brian Koberger hearing. This is a pretrial hearing. That trial is still slated for August. That is still going forward as we know it, and it's today's hearing is going to be a spicy one because it's going to talk about what evidence is going to be allowed. Like, are they going to be allowed to bring in the knife sheath, right? The K-bar knife sheath with the DNA on the snap. That little snap where that has his DNA at the crime scene. That's sort of important to this case. Things like that are going to be discussed. It's going to be great. It's going to be spicy because this is the best chance I think the defense has to win, is to keep evidence out, and we'll see how that goes. And there's a ton of evidence. I mean, Amazon search histories and purchase histories, and all sorts of cell phone and everything else. So it's going to be good. We'll have that over there on Top Mark Media, and it will just be playing straight from the court, which has decided not to use YouTube anymore as a source for its video. It's going straight through the judicial live stream page. It sort of went professional instead of using a third-party media server. So, can you remind me what they're charging her with at this trial? Conspiracy to commit murder. No, that was Lori Vallow. Sorry, murder. It's a murder trial. I doubt this judge will deny cameras. They've been releasing everything that the other judge sealed. I would hope so. I don't think. Yeah. If anything, they just went more professional with the way they're providing the video to the media and everyone, because you can all watch it. It's open to everybody. All right. Let's see. We're going to need terabytes. I think these are 4 terabyte. 2 terabytes. So I've got 4 terabytes of data on NAS storage to record to. And that's not enough. It's not enough. If I compress it, each one gives me about 60 days of recordings. So that's only 120 days. I need more. The judge is doing it the right way with BK. I agree, Blair. I like that he opened things up. We should be hearing more about that case moving forward. Are we jumping over to BK when it starts? No, Bryce. I'm going to have it over on my second channel, which is Top Mark Media. So we'll stick with this court, which is right here. Oops, that's not where we are. We're right here. We'll stick here with this court and follow this one through till the verdict. And then at the same time today at 11 o'clock, which is in just under 25 minutes, we're going to have on Top Mark Media channel, which is my company name, Top Mark Media. We're going to just air the straight feed from court, because the Idaho court, they do share the feed openly. And here's the link. Thank you very much. They share the feed openly, but as soon as it's over, it is gone. It's gone. And a lot of people watch this afterwards. They watch it on replay. And if the court feed's gone, they have nothing. They can't watch. They just have to listen to what everyone else said they saw. Let's see. So the guy sitting by her is her boyfriend. Do they allow that? Virginia, I didn't see. He's not allowed up in front of the bar. He's been in the gallery. Are you talking about Linda Stermer? Her current boyfriend's in the gallery. Josh, now everything I have is tied up. I can't record anything else because once I connect this last plug, it'll be recording Koberger as well. We're going to be 2 places at the same time. Okay, this argument, man, this gets me, okay? The argument that the defense has brought up, or the statement the defense brought up, and I didn't like it when they got it out of the original fire investigator, and I didn't like it when they approached the content, the same topic with this new their fire investigator, saying that it's impossible to be 2 places at the same time. Agreed. So Linda says she was in the basement. So you now have evidence that she was in the basement. So that would make it impossible for her to be where Todd was, where the fire started. Thus, Todd is the source of the fire. No. First of all, you have to believe Linda, which most of us don't. And that's fine. You can believe her, and that's great. But second of all, you can have the fire, the gasoline poured on Todd, and then across the floor, and then leave, and let the fumes find their way to the fireplace, and woof, and she could be in the basement at the time. So yes, she's in a different place when the fire started. She's not there when it ignites. But then that next question, which was objected to, and rightfully so, that thus she had nothing to do with the cause of the fire, that was completely out of line and a bad conclusion. All right. What's KR openings Tuesday? Karen Reed openings on Tuesday. We'll be going there on the main channel. Let's see. Ann Taylor believes him, like really believes him. I hope she does. I love it when a defense attorney is fully invested and believes in what they're doing. It makes them a very passionate argument. It makes for incredible work ethic. I love it. I think it'll be a better trial if she actually full on believes that he is innocent. And she said that. She's like, we full on believe he's innocent. Let's see. We've got 1,973 people here, and 666 of you have clicked the like button. We need one more. Let's just not leave it at that number. Will chat be open at Top Mark? Yes, it's open now, as a matter of fact. We've got a few mods over there. Red Pen, who is one of our mods here on Top Mark Media, is there. Samantha Terry is there. And we've got a few other people. And I will say that on Top Mark Media, we still don't attack people and be mean, but it's sort of like the channel's Vegas, right? It's a little more lax over there. It's not set up as much as a family-friendly. I mean, we still don't want people spamming all caps and yelling at each other and things like that. But sometimes the conversation can deviate from whatever's happening at the time. And it works fine, because if you don't want to follow the conversation, you can just watch the video. I won't be talking over anything over there. So you can have a little more fun over there, but please just respect the mods. Don't make their job terrible. Can you talk about the red towels quickly? Great question, Angelique. Why it wasn't brought up in so many questions you had after? Why it wasn't brought in so many you had questions after your comment? Yes. Okay. First of all, the red towels soaked in gasoline. This was evidence that was in the first trial. There were towels in the washer or dryer that had evidence of gasoline on them, where she said she was working at the time of the fire. That evidence was not brought in this trial because the company that did the testing on those towels went out of business and the records are gone. And under Michigan law, for an expert to testify about the results of a test, the underlying evidence has to be available, and it is not. And that is the only reason that evidence wasn't coming in. The state was planning on it. They had their expert on the stand to testify, and it could not come in. The judge ruled the law says what the law says, and it's not available. This one, time works out for the defendant on that one, so the red towels don't come in. Now, if the defense, in questioning their witness, which they did today, said, you said you had evidence that she was not at the scene of the place of the fire when it began. What evidence do you have? Just ask him. And if he then said, and that's an appropriate question, because defense questioned him directly on it, so they sort of cracked the door open. It's not open any further to say, what evidence do you have? If he lets it slip that there were towels in the basement, red towels, the door's open. I don't think he will, because there's nothing positive about that for the defense. But if anyone does let something slip, I think it might be this guy. He talks, and he won't have the guiding hand of the defense attorney to steer his conversation. His propensity to wander in his answers could be very, very beneficial for the state here. So fingers crossed, if you're hoping for that to come in, this is going to be the last chance. The state's already rested their case. It's not coming in on rebuttal. So there we go. Let's see. It's cracked for sure. It's a small crack, and it requires you're making a 30-yard chip at this point. As far as the odds go, it's not very likely at all. I wouldn't hold your breath for it, but there's a chance that through this it can be opened. They still can't bring in the gasoline test results because the base data is still missing. Yeah, but if he says something, the jury's going to hear it, and that's a bell you can't unring. He's not going to slip up. Even the more I talk about it, the more I think there's no reason for him to. He may not even know about it. Now, and you say, why? Why would he not know? A lot of times an expert is given a very narrow view of the case and told to focus only on this and not provided with outside periphery information to prevent something like this happening. I would think saying there was no other evidence of gas would open the door for the towels. Did you miss the polyester video? No. Oh, I think we're just getting to the polyester video, right? I saw the... Did I miss the polyester video while I was plugging things? I didn't see the polyester video yet. I only saw the storage unit fire, which was filmed in the true Blair Witch Project manner. It was terrible, terrible film work. Let's see. Linda says there are three of us who will make good jurors. I'm not a good juror on this case. And the problem is I'm looking at this case through the lens of the evidence of the prior case. So I feel like I've seen the evidence because on the research on this one, I've looked at so much of the evidence that came in the first time, and I agree. I mean, I agree with the appellate judge who said there is zero chance that she's not guilty. This is not a circumstantial only case that it's just like just the most reasonable. No, this is a good one. All right, could be a jury question. Yeah, we have to look. We're looking for shorts on a pole in a driveway. The pants video is coming in. We've got the stipulation that's been read to the jury already, so I think it's coming in. Let's see. I've never seen the Blair Witch Project. I just know the video reference. Pants on a pole. Pants on a pole. Yes. Better than pants on the ground, right? We will do a poll at the conclusion of the evidence for the defense. I guess technically we could do one at the conclusion of the state because that's the end of their evidence. But when the defense is over, there might be more rebuttal, which is then evidence for the state. So we'd like to wait until the end of all evidence before we do the poll. It would be wild if the jury asked about the red towels. It would be a mistrial. First, the juror would get pulled in, and you'd ask, where did you hear that? Because no one in this trial has mentioned red towels. Okay, I need them to come back really quickly because I've got to plug in the cable super fast. I don't like the court system the Idaho uses, the video player they use. It is terrible. Plus they just start when they start, and it's like mid calling the case is the first thing you hear. And I've got to catch all of it. No, I'd get a quick copyright strike for playing that. All right, any other questions about the Linda Stermer trial? Josh, remind me in a minute. I'm torn between like 6 things right now. I'm trying to watch. Corey Richards postponed indefinitely. Thank you, Carter, for this. Corey Richards postponed only while the appeal is heard. Her team has appealed the judge's decision not to move the trial from Summit County to Salt Lake County. Corey Richens is the mom in Park City who was accused of killing her husband with a fentanyl poisoning. And then she wrote the children's book and went on the national book tour. Are you with us? She wrote the book about, children losing their parents and all that. Now she's accused of his murder. And that trial's been spicy because of some of the stuff that Corey has done, some of the things she's written, especially from jail, the wag the dog letter, or walk the dog letter. I always say wag, but there's crazy stuff. That's going to be a wild, wild case. We have been there in Park City for a couple of the hearings already. We will be following that trial as well. The book about grief, yes, written by the one accused of his murder. Regrets, I've had a few. Boy, this is a tough one. Watching Linda in the courtroom as her sons are testifying against her and testifying to some of the things she did. Now I realize every parent probably has some moments that they're not proud of that their kids could say, yeah, mom did this, dad did this. That every parent probably has a couple moments where like that wasn't the best parenting moment for me. But this is next level stuff when kids testifying that mom told me to beat him up, to silence him if he ever said something about her in a bad way. Whoa, that's hard to hear. It's hard to hear, let alone the fact that, mom's accused of killing dad. Mama Yenny, happy birthday. Happy 40th birthday. I'm sorry we missed you with the birthday song this morning. We're going to stream BK Live over on the Top Mark Media channel.
Back on the record in the case of People versus Linda Stermer, any matters to address before we bring in the jury?
Yes, Your Honor. Can we approach to address it?
You may.
I thought I would have a minute to plug in a cable, but apparently not. Yes, we have a second channel. We typically only use it for feeds like this when we're following the main trial, and there's another really spicy one that we have permission and access to use, and we can just put it up just as a clean, what we call a clean feed from the courtroom. You need some cable plugging music. It would sound like I don't know if what the polite term would sound like, baby making music. It would. I mean, that's, to me, that's. BK starts at 11. We've got about 9 minutes. 9 minutes before that one begins, and it looks like about 30 or so of you over there already on the channel waiting for that to start. We'll get that going here in just a moment. Sultry music. That's the polite term. Bum, 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 bum. Yeah. Like bound chicka wow wow, that type. Brown chicken, brown cow. That's what I'm thinking. The hearing, Jackie, the hearing is today. Brian Koberger's trial does not start till the early toward middle of August. I think it's the 11th of August. And the judge has tried to lock that date down. Barry White. Yes, that would be a good one.
Any other matters, counsel?
No, I don't think so, Your Honor.
Anything else, Mr. Blair, from your end?
No, Your Honor.
Okay.
All right, we are bringing the jury. Oh, man. Dave Beltrell, can you imagine if we were watching something on the West Coast? Like, imagine if we had a Hawaii trial that we were covering. Oh, that would be terrible. We could literally work 2 full shifts. We could cover an East Coast trial in the morning, start to finish, gavel to gavel, and then start our Hawaii trial in the afternoon. Somebody look for a good Hawaii judge. There are a couple spicy ones down there. We've been to a Hawaii court, I think, one time. You guys remember what that was? I just remember it was spicy. No sleep for us. No sleep at all.
Welcome back, jury. And sir, you're reminded that you're still under oath.
Yes, Your Honor.
Thank you. Mr. Mueller?
Thank you. Mr. Treckle, I just wanted to make sure I summarize when we're talking about the excavation. Just to put a bow on it, do you have an opinion whether Mr. Leroy did what he said he did?
Objection, asked and answered.
Your Honor, we're
That
summarizing.
you haven't already covered?
Just summarizing one point. That's all.
Why don't you be specific about what he did what?
In terms of the excavation, do you have an opinion that he actually did that?
Objection, asked and answered, Your Honor.
Summarizing it.
That part has been asked and answered.
I'm just summarizing, Your Honor.
Okay, we don't need the summary.
right.
Thank you.
Mr. Leroy said in his testimony that gasoline can completely be burned up, which is why there's no evidence, zero, of gasoline in his area of origin, the living room. Is that possible?
Possible, but highly unlikely. But absolutely, you can't say that because he didn't excavate, so how can he find if there was or was not gasoline there? There was no excavation, so there was no evidence taken and no analysis. You can't just arbitrarily say, well, gee, you must have been consumed in the fire when you didn't even try to find it.
Is there evidence in the rubble that you've seen that would suggest that if there was gasoline, it would have been found? Like in terms of how the material is and whatnot?
I say that it would or would not be is dependent upon the fact that somebody actually tried. I have not seen, if you do an excavation and you have other proofs or data that suggests that there was an accelerant used, that you find it.
Let's talk about the gasoline on the 100% polyester sweatpants. First of all, just in order to set this up, I want you to look at that big binder there.
This one?
You did an examination of all the clothes in this case?
I did.
All right. And you saw the clothes that was taken out of, we saw these silver cans and whatnot?
I did.
All right. I want you to look at Exhibit M. All the various pages, and just tell us if that represents the clothes and the packages that you saw in your examination.
There are various packages and items that were placed into evidence, which I think they're in this room too, that were recovered. I actually saw most of them, I think, also. Well, I didn't see some of these.
Okay, but you saw the evidence and included the sweatpants?
Yes.
All right, move for the admission of Exhibit M. They represent what was presented to us at his inspection.
No objection.
Thank you.
Exhibit M. Did you say M as in mother? Okay.
Mary. Thank you. I want to have you take a look at a couple of the pictures from Exhibit M representing the sweatpants. Are those the sweatpants that you saw?
They appear to be.
Okay. And then this, did you have an understanding of the material that the sweatpants was made out of?
Yes, I do.
100% polyester?
Yes.
Okay. Did you obtain some polyester 100% polyester sweatpants?
I did.
Okay. Did you run a video of a test of an exemplar
Yes.
With and without gasoline?
Yes.
Did you bring a pair of the exemplar 100% polyester sweatpants with you?
I did.
Can I show that to the jury? And I'd like to move for the admission of Exhibit Q.
They're in this bag. You want me to take them out?
I don't think that's...
As long as the court reads the cautionary instruction.
Thank you. You want me to read it now?
Yes,
or,
please.
Right, it's a good time to read it?
Let me set up the foundation of the video. The video, you did a video showing ignition of 100% polyester sweatpants with and without gasoline?
Yes.
And how much gasoline did you use?
2 ounces.
Okay. What was it intended to show?
It's intended to show the difference between a fire that is accelerated in the presence of gasoline in the incipient stages. Well, it doesn't really ever have an incipient stage, to showing that with a match, our lighter polyester resists burning. If it does, it starts melting as opposed to burning.
Okay. You can go ahead and read the instruction, Your Honor.
Thank you. I will admit the video into
Yes, and
evidence.
let me just formally move for the admission of Exhibits R and S. R without the gasoline, S with the gasoline.
R and S, Mr. Blair, any objection then? I'm going to read the instruction. Okay. Jury, an instruction for you. This video is being admitted only to illustrate the witness's testimony. The parties agree that the video is not in any way a recreation of the events at issue in this trial. You may only consider this video to help you understand, well, I think there's 2, right? 2 videos here. To help you understand and evaluate the witness's testimony as it relates to how polyester clothing might burn when doused with 2 ounces of gasoline versus how it might burn in the absence of any gasoline. Satisfied?
There was an instruction about the exemplar sweatpants as well.
We had one sentence.
Oh, that's the 2-sentence one. Did one of you, did you email it?
I did.
Okay, another instruction, jury. The sweatpants you will see in the video are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. Okay? Satisfied, counsel?
Satisfied, thank you.
Thank you, Your Honor.
Okay, thank you.
We're going to show
I think we're admitting all
R and S.
R and S, and then I he admitted.
Thank
Yeah,
you.
what happened to Q?
That's the sweatpants.
Q, yours.
Oh, Q, I'm sorry, yes,
Okay,
Q
Q
is
too.
the exemplar.
Okay, and you're good, Mr. Blair?
Yes.
Okay, we'll admit those.
I'm going to show Exhibit R without the sweatpants first. Without the gasoline.
Here we go. Give me fuel, give me fire, give me that which I desire. I'm using Metallica music in the background here. This looks highly scientific, like many beers were involved in making of this video type of stuff. It literally is pants on a pole. Let it burn. So this trial was suggested to be the liar, pants on fire trial. We didn't go that way because it prejudges the defendant, which we might have done anyway. But
Okay. Now I'm going to show Exhibit S, and tell us what you did.
I took a 4-ounce metal measuring cup and I filled it half full with 2 ounces of gasoline. And then pants, same situation. And I threw it at it, backed up, and then threw a match.
Okay.
And ignited it.
that's like 2 tablespoons of gas.
Can I make a comment, Your Honor?
No.
Your counsel.
Well, I need the picture on there to do it.
You can illustrate what we're talking about.
Well, what I want to do is let the jury see the darkened color by the liquid and that see that stays last thing to burn because it was still liquid.
And you can see it.
That helps
what is
the
it doing
state.
right now? It's burning and doing what?
That
And
helps the
melting and,
state.
Falling to the ground. But I just want, you could see right in the beginning of the picture that when I threw the match, the liquid didn't ignite, everything around it ignited, and that's what I wanted them to see. That would be the first seconds of the video.
If he
And
was
as it's
soaked in
continuing
gasoline.
now, it's just dripping and burning, because of the presence of the vapors of gasoline. Otherwise, it wouldn't do any of that.
Remind me not to wear polyester pants, because that is scary. His comment that the part that's soaked in gasoline is the last thing to burn. That part, as long as it's wet with gasoline, is not burning. The gas, this off-gassing from the gasoline is burning.
You're showing the pants, but also is the waistband burning?
Yes, the one that's still hanging, on the post. What is really starting to burn is the waistband because that's not polyester. It's a stretching material that is not polyester. So it keeps burning and keeps the other heat enough to have the pants still sort of stay lit.
That portion on the ground that has not been consumed yet is the part that had gasoline on them. I think for this test to be really insightful, you'd need a full pair of pants, soak them in gasoline, light them on fire, and while they are initially burning the gas, scrunch them up into a small ball.
Let's talk about Mr. Leroy's opinion that there was an open flame to gasoline. Okay?
No. Okay.
Which was the open flame was what he considered an ignition source, remember that?
Yes.
And the gasoline, despite there being no gasoline in the area of origin, right?
Correct.
Okay. Does NFPA talk about that whole concept? First of all, there was no evidence, or did you find any evidence of an ignition source in anything he did?
No.
Okay. So what did he do? Make one up?
With the evidence he had, he would have
speculation, Your Honor. Make one up.
I'll sustain that objection. It calls for speculation.
If you're supplying an ignition source where there is no evidence of it, does NFPA 921 speak to that?
Yes.
Now you said that gives guidance for everything that investigators are supposed to do?
Yes.
Yeah. first of all, let's look at 23.2.7.3. Can you read that?
23.2.7.3. It should be right next to the one I have, but I guess I'll do my best reading again. The investigator is strongly cautioned against using subjective opinions to support his incendiary cause determination in the absence of physical evidence.
Okay. And 19.6.5 tells us
identifying the ignition source for a fire by believing to have eliminated all ignition sources found, known, or suspected to have been present in the area of origin and for which no supporting evidence exists is referred to as negative corpus.
Okay. And then finally, negative corpus is defined in 4.3.6.1 of NFPA 921. And that tells us what?
Any hypothesis that is incapable of being tested, either physically or analytically, is an invalid hypothesis.
And?
A hypothesis developed based on absence of data is an example of a hypothesis that is incapable of being tested.
Okay. So NFPA guides us in that. And Mr. Leroy found no evidence of an ignition source, right?
He did not.
And why didn't he? In terms of excavation?
Well, he didn't do any excavation, so how can you find something if you don't look for it?
And a first fuel, can you tell us what first fuel ignited means?
Means the first, well, when we talk about fuel, it's fuel load. It doesn't have to be a flammable or combustible liquid. Could be your clothing, could be something that's not a hard piece of wood. Something has to have an ignition that can be a chain of ignitability to start burning everything else. But simple household furnishings and things like that.
And so in simple terms, it's the first thing that catches fire?
Yes.
All right. Do you also have to, well, we talked about you have to tell us how the ignition source and the first thing that caught fire actually came together.
Sure, because there's all kind of ignition sources here and all kind of flammable or fuel, but you and I are all fuel, and if there's no ignition source and no, well, say there is an ignition source, say something is burning in this room, but you need to find out how that came together to burn one of us, basically.
Okay. And if you can't find all three things that we talked about, you have to determine, in terms of a cause, you have to say it's what?
It's undetermined. You can't, if you don't have any of those things or part of those things, how can you come to a definitive conclusion and say it is accidental and or incendiary?
And if you don't have a cause of a fire, can you classify a fire?
The only classification comes under classification is undetermined.
Okay. Can you describe the four classifications for us?
Well, I usually think there's only three, but there's one that's called natural, which I always put as accidental, like the act of God, lightning, earthquake, things of that nature is a natural fire. Fire that's accidental obviously speaks for itself. A careless cook on a stove, any number of things that can be done accidentally without having intent to do anything wrong. And the other one is an intentional act. An incendiary fire is an intentional act to cause a fire where it's not supposed to be caused.
And only one supports a crime?
Yes.
Would that be an incendiary fire?
Yes.
And given that Mr. Leroy didn't do the fundamental excavation to find the evidence, what level of trust do you put in any of his opinions?
Well, because things weren't done like they need to be done, no matter for what reason, you can't really then opine that you have anything but an unintentional or an undetermined fire. You can't say one way or the other whether it's accidental or incendiary if you don't do the job to finish what you need to do to get that information.
So, in your expert opinion, let's start with the origin, given that you said he didn't adequately consider the chimney chase for one. What trust do you have in his opinion that the living room is the area of origin?
I don't have any, because if the fire started in the chimney chase and then extended to the living room, there is no way of telling the difference because of the destruction of the property. It's too badly burned, and that hypothesis, particularly of the chimney chase, as I say, Mr. Leroy actually gave a whole page and a half of his definition how it would happen, but he says it couldn't by no other reason.
And now, how would you determine, forget the origin now, going to the cause, what classification is the only one that you could come to given the evidence in this case?
Certainly if you had no evidence of where the fire actually originated, it would certainly be even more so impossible to determine a cause. You cannot put a label on something that you're saying, well, how? And if you haven't got the answer to the first one, you certainly can't have the answer to the second one.
Okay. So that classification would only have to be
undetermined.
All right. Do you place a lot of importance and weight on what classification you're going to give to a fire when you're doing your analysis?
Yes, absolutely.
Why?
Because what you're saying, particularly, well, in any circumstance, if you say the fire is accidental and it might affect another family member, and because you did something stupid, for example, you set a situation between people that aren't very good, and if you made a wrong determination even for that, you might cause family strife. If you call something incendiary, that is something that's so important to make sure you have the right call, because you alter people's lives, you change people's lives.
Actually, Your Honor, I don't think he can testify to this. This is well outside the scope of expert opinion.
He is an expert, and this is the kind of thing he considers when coming to a determination of a classification, because there are ramifications. That's what he's testifying to.
Thank you. I think the jury understands that. I'm going to sustain the objection.
Okay. Let's talk about Mr. Leroy's
one more grunt there.
Causation issues with respect to time of day, two able-bodied people, and an abnormally fast fire. We talked about the abnormally fast fire, right?
Yes.
All right. Do you recall Mr. Leroy testifying in the course of this case that the cause of the fire was because of the time of the day and two able-bodied people were in the house, only one survived?
Yes, I recall that.
Can you show us 921, the book?
I can show you 921, but you're not going to find anything like that in the book.
Are you going to find that in any book?
No.
Are you going to find that with any credible source or authority in the fire investigation business?
None.
How about the idea of two able-bodied people? That was the time of day. Two able-bodied people. Do able-bodied people die in accidental fires?
Able-bodied people die in fires, get out of fires, but that is not anything to do with origin and causation of fire.
Okay. What is your opinion as to the quality of Mr. Leroy's opinion about that?
Well, he's totally in error, and he never learned that in school. If he did, we need a new school.
Let's talk about this red gas can that was found in the front yard the next day. Have you looked into that idea of somehow could it be related to this fire?
Yes.
Okay. I'm going to show you Photograph 32 from Mr. Leroy's photographs admitted to one of the prosecution exhibits. You see this picture taken the night of the fire and that red gas can?
I don't know that I have that.
It's up on the screen.
Oh, I guess I don't have to look at it. Yes.
Okay.
I do recognize there was several pictures like that.
Tell us what impact all this firefighting equipment has on the possible location of that.
Objection, speculation.
No, he's been a firefighter. He knows when to drag hoses around. Thank you.
Well, when you can see in the photograph that the gas can is being encircled by hose lines, which are pretty heavy when they've got water in them. They don't just pop up. When you're dragging around, they're dragging whatever might be in that perimeter. And so that gas can, I know, had been moved because...
Your Honor, he can't say he knows it was moved.
There's been no foundation for that response, so unless he lays a foundation, I'll strike the response.
Okay. When you were a firefighter, do hoses stay in one spot or do they move around as you're dragging through the fire?
Firefighters are moving the hose lines wherever they are necessary to try to extinguish the fire. And sometimes you have it in one location, you get the fire that you think controlled there, and you go to another avenue to try to put it out. If you look at the front of that house, there's holes cut by the firefighters to give them access to be able to put water into that house. And you'll see it all the way around the house. But so that line is being dragged around all over the place. And with the gas can being right in the middle of it, it's impossible for them not to move it.
Objection, Your Honor.
I'll sustain that objection and strike that response. Jury, don't consider the response, please.
Okay. The next day, Mr. Leroy showed the photograph. And do you recall, do we have that gas can here? Okay. That the spout was broken in two pieces?
Yes.
And the gas can was very muddy?
Yes.
All right. Do you recall, or did Mr. Ernst, the MSP analyst testimony, affect your opinion on whether the red gas can had anything to do with this fire?
Yes.
What did you rely on in terms of Mr. Ernst?
Well, there was no liquid gas in that container. It was vapor. He takes and heats this, whatever he has, if it's a metal evidence container or if it's a nylon bag, he heats it up with a heated headspace and takes a syringe and pulls out a headspace and then analyzes it. There was, by his chromatograms and mass spectrometry, as I recall, he said that it was evaporated gasoline up to 85 to 95%. So that also is important.
And do you recall him describing it as the fumes representing old gas?
Yes.
Did that factor in?
Yes, that would be the case.
Okay. Do you recall what Mr. Leroy admitted as a fire expert as to whether the gas can had anything to do with this case?
He said he could not establish there was any link between the fire and that gas can.
Because there's no evidentiary basis for that?
Yes, correct.
And is that your opinion as well?
Yes.
Do you also recall what he said in terms when I asked him, well, if you were to have that opinion, you'd be speculating. You remember that?
Yes, and speculation, well, yes.
Go ahead.
Speculation is a guess. It has no evidentiary value.
And if you masquerade a guess as an expert opinion, what are you doing in terms of putting out your opinion as an expert?
No objection, Your Honor. I don't think that's a relevant question.
This absolutely ties into what Mr. Leroy admitted.
I think this goes more to argument. Counsel so sustain.
Yeah. Do you recall Mr. Leroy saying that would be misleading the jury?
Yes, that would be misleading.
And do you recall Mr. Ernst saying that would be misleading the jury?
Yes.
Any opinion that is based on speculation would be misleading the jury?
Misleading whoever, the jury in this case.
Okay. Do you have an opinion? Mr. Leroy said that he complied with all the dictates of NFPA 921. Do you have an opinion whether that is true?
That he did?
Yes.
I have an opinion, yes.
What is your opinion to the jury?
My opinion that obviously he did not. We've come up to several different areas. We've explained that he did not follow, or, you know, because you claim to have done it, the evidence speaks for itself, or the lack of evidence.
Okay. He claimed that he complied with all of the dictates of the scientific method, which is required for your business. Do you have an opinion on whether he did that?
Yes.
What is that opinion?
Opinion he did not. Everything that you've had before you and everything that I've seen as a person following up on this case, there is the fact that he said he did an excavation, and there's photographs from Mr. Shinsky that shows that he did not. The fact
and
that
Mr. Shinsky's admission that he did the...
Oh yes, Mr. Shinsky said he did the excavation. We saw the heavy equipment out there and other people there helping in that excavation. And then the fact that Mr. Leroy doesn't have any photographs of that excavation, and he has nothing to prove that he had done it and everything to prove that he didn't.
So what does that suggest to you about Mr. Leroy's testimony about whether he did it?
Well, he's telling an untruth to you.
At this point, you're asking, going into the province of the jury as far as truth and falsehood.
Do you have an opinion as to whether Mr. Leroy adequately documented anything that he did in terms of collection of data, evidence?
Anything he did? No, he didn't.
And finally, as to any of Mr. Leroy's opinions, what is your level of confidence and trust?
I guess I'm going to object. I think we're starting to invade upon the province of the jury.
No, that's his opinion based as another professional.
One more time, my concern is cumulative, but I'll allow you. It sounds like this is the last question on the issue.
Go ahead.
Well, the fact that all these things have been presented to you, I have little or no confidence in his opinion.
Okay. Let me finish up a little bit here with, you and I have been doing this work now on this case since the end of 2018 when you met me.
Yes.
Right? How many hours do you think you have in this case?
Upwards of 2,000.
Okay. And you've testified in criminal cases before?
Yes.
On behalf of the prosecution?
Yes.
And on behalf of the defense?
Yes.
And you've testified in civil cases on behalf of insureds, the people who have insurance?
Yes.
And on behalf of insurance companies?
Yes.
So you, in every aspect, you've been retained and testified by both sides?
And sometimes third-party cases where it's subrogation, that one company says another company's at fault for causing a fire. Yeah, so that's not either side, I guess.
Okay. Let me just take one quick second. I'm going to return to this.
See if he's done here. I'm trying to listen with two things. I've got right ear listening to Koberger. Quick huddle here.
Mr. Trankel, have we covered all the subjects that you wanted to have covered in terms of what you were assigned to do and review?
Yeah, I believe you did.
Okay. In terms of Mr. Leroy's documentation of his work, were you hamstrung in any way?
Well,
Your Honor, I guess I'm going to object. I think he's already talked about the adequacy of the documentation, the questions have been asked and answered.
That hasn't been asked and answered, Your Honor. I can tell you that.
I'm not clear where you're going with it.
Just what affected the lack of documentation and the inadequate?
I'll allow it.
Thank you.
Overruled.
Well, many times, coming after the fact, even, excuse me, when it's been years even, if there's adequate documentation, I could actually make a definitive opinion what may be the cause, either agreeing or not agreeing with the person, but actually coming up with a cause rather than me saying it was undetermined. So that's been the problem in this case.
Okay. But in any situation where you can't rule out different theories or ideas of what could have happened, where it could have started, what is your obligation as a fire expert to call it?
My obligation is to be truthful and call it undetermined. I can't tell.
And in this case, is the area of origin just too big because of the damage?
Objection, asked and answered, Your Honor.
Yeah, I'll sustain the objection.
I don't have any other questions for you. Thank you, Mr.
All right.
Frankel.
Here we go. This has to be a fiery cross, pun intended.
Take that down to the...
I'm going to take everything down.
Okay, good.
Yeah.
Blocks. Excuse me. Mr. Blair.
Thank you, Your Honor.
Thank you, Mr. Kelly.
Thank you, Mr. Kelly. Good afternoon, Mr. Trenkle.
Good afternoon.
I'd like to kind of circle back to something you said. You indicated you have 2,000 hours into this case. Is that correct?
Roughly, yes.
And you're billing for those hours, correct?
My billing is zero.
You're billing zero?
It's the same as all the other people working in this case.
So ordinarily, sir, you charge $225 per hour, correct?
That was my old fee. Now it's $275 for investigative and $350 for court testimony.
I understand. So you're not receiving any compensation at all for your opinion or to come here to testify today, is that
That's
correct?
correct. The whole crew of us are getting nothing.
Do you expect to receive something later?
No.
So you indicated that you received, you reviewed all the documentation in this case, is that correct?
All that I was provided.
Okay, what were you specifically provided?
Specifically, all the different, they're in the computer, most of my things. It was provided the initial fire report from Lawrence Township. I was provided the initial investigation report by Mr. Leroy. I was provided the report from Mr. Shinsky. All the statements under oath by Ms. Stermer, the information that was on recording by Mr. Shinsky of what Ms. Stermer had to say. Photographs, hundreds of photographs from all the responding personnel. In fact, probably most of the reports from, maybe all the reports, but I don't know. I got what I got. But from Maziowski and Ms. Rout and the lab reports, all those kinds of things. Plus, I conduct, well, you said what I was presented. I'm sure there's more.
Okay, fair enough. But my main point, I guess I'm going to get to too, is you were provided the various statements of Linda Stermer, correct?
Yes.
And you reviewed those statements, correct?
I did.
And those statements, she would be considered, at least at the onset, an eyewitness in this matter, correct?
Yes.
And eyewitness statements, you're allowed to rely upon those according to NFPA 921, correct?
Yes, you do.
And eyewitness statements are relevant, could be relevant in not only determining the area of origin of the fire, correct?
Yes.
And they could also be relevant in determining the cause of the fire. Is that also correct?
Some instances, yes.
And you indicated during your direct testimony that to you an excavation means an archaeological dig, correct?
That's the way it's mostly described, depending on the depth of it. I think I also said that sometimes you don't have an archaeological dig because there's nothing really to dig through, and I think I said something like about a fire in a kitchen stove.
Well, I guess to my point, NFPA 921 does not use the words archaeological dig anywhere in the text, does it?
They do not. Well, I don't think they do.
So when you say archaeological dig, that is your words and your definition, correct?
I would say that's the industry's definition by most people. If you want to try to describe what you're doing, what better way that you describe it than saying we have a pile of debris. We know the top part is probably the remains of the roof. The next one is their two-story building, the next floor, and the next floor. But in this particular case, it's the roof.
He's not answering my question.
I think it's...
Yeah. I asked very simply, the use of the words archaeological dig, those are your words.
And then I replied, it is the industry's words also. We know by...
Okay, that's good.
Okay.
Thank you. As a matter of fact, NFPA 921 uses the words adequate when it comes, or the word adequate when it comes to excavation. Is that correct?
If you have, well, it says inadequate, so I guess maybe adequate is something that they may say, but I think adequate could be misinterpreted. But
fair, because adequate's a subjective term, isn't it correct, sir?
Yes.
Or inadequate's a subjective term, correct?
Exactly. One way, one the other way. Yes.
Right, because if I was a fire investigator and I was reviewing potentially an excavation you did, I could come in and say, your excavation was inadequate, couldn't I?
Probably not behind me.
Well, that's not my question, sir. My question is, as a reviewing cause and origin expert, because of the subjective nature of the term, I could come in behind you and say, you did an inadequate job excavating, correct?
And if you did, you'd have to establish that I actually did an inadequate
Your Honor,
job.
can he please answer the question?
You can answer yes or no.
All right. It's kind of hard to answer yes or no to that question.
The last one, I think, was possible, so.
Okay.
You may want to limit your, narrow your
could he
questions,
repeat it?
Mr. Blair. Yeah, we'll have him repeat.
You would agree with me that as I was a fire expert, I could come in behind your investigation, your excavation, and I could say it was done inadequately, correct?
I guess you could say that if it was you.
As a matter of fact, in this case, Mr. Leroy did do an excavation, correct?
He did move some things, yes.
Well, you saw the pictures from Mr. Shinsky, correct?
Yes.
Were you present here for his testimony in court?
I don't think I did that. I think I saw that online.
So, would it surprise you to learn that the photograph Mr. Mueller showed you of the back of the Stermer residence with the various piles out back was taken by, you understand it was taken by Mr. Shinsky?
I'm not sure who took it. I know that it was different than, go ahead. I don't know who took it.
All right. Well, it was part of a packet of Mr. Shinsky's photos that were shown to you, correct?
I think it was, yes.
And would it surprise you to learn he testified that he took that photograph before he did any excavation?
Yes. No, it wouldn't surprise me. No, not at all. It would not surprise me.
Foundation, I'm not sure what photograph he's talking about.
I asked about the photo of the rear with showing piles of debris.
There are pre and post
I'll overrule the objection as the witness has answered it and seems to understand what he's talking about.
Okay, thank you.
Yes.
And so that would then indicate that Mr. Leroy did an excavation of the Stermer residence, correct?
Yes, there was obviously evidence, and I could even point out what I think he did dig through, but go ahead.
Okay, but your complaint is just with the adequacy of the excavation, correct?
I guess yes.
You guess yes or yes?
Well, I think I have to describe what I saw that was left that certainly would make it inadequate.
Again, my question, sir, is you take issue with the adequacy of his excavation, correct?
Yes.
You were also shown some photos of after the excavator hired by Mr. Shinsky had begun to remove parts of the residence, correct?
Yes.
And you were testifying, I believe, about how there was debris that was down, would be like in the basement level of the Stermer residence. Do you recall that testimony?
I commented there was debris, yes.
Okay. And you would agree with me that when an excavator is operating and removing things, things are falling into the residence as they're being broken loose by an excavator, correct?
Depending on the quality of the excavator. The excavator people I would hire would not let things fall back into the house.
Well, some of that may be out of their control though, right?
That's why they take painstaking care in how they do what they do when they're not just moving debris around to throw it in a 40-yard dumpster and have it transferred somewhere.
Well, you would agree with me that if I grabbed a hold of a large chunk of, say, roof material or something with an excavator, as I'm lifting that back with an excavator, things might fall off, right?
They might.
You had opinion about the area of origin in this case. Do you recall those opinions?
Yes, they're multiple.
Okay. And you would agree with me that NFPA 921 does not contain any size specification for the area of origin, does it?
There is nothing that says it has to be 6 by, no, there is no, you're right.
So for instance, an 18 by 18 living room could in fact be the area of origin, correct?
You would be correct maybe that it was the area of origin, but if you did nothing to limit that to a smaller area, I just never seen it happen before, I guess.
There's no requirement that you eliminate it to a smaller area, is there?
There is no requirement that says it, yes.
So this is just, again, your subjective opinion about what should be the area of origin, correct?
If you had a house fire like this, you might as well call the whole house an area of origin, even though we know there was no fire in the east and the south sections, if that's what you're going to say. In the industry standards...
I don't think this is responsive to my question.
Sir, why don't you restate your question so he can be more responsive?
I'm sorry.
Okay.
Sir, what I'm asking you is... Well, I kind of forgot my question. I'm sorry. Yeah, your opinion in this is subjective, that the area of origin must be narrower than the living room, correct?
Yes.
You indicated, I think, on direct that you determined or you believed the area of origin was the chimney chase. Is that correct?
I said it may be because I can't isolate that and this living room, and I believe the only reason that Mr. Leroy said it was the living room because he's got gasoline in it, and that limits him from having to worry about that. And he also said that in his testimony.
Well, let's talk about that, sir, because that's interesting. You said you could rely on eyewitness statements, correct?
You decide by the physical evidence if what someone is telling.
Again, Your Honor.
No, you rely on it.
I asked him if he could rely on eyewitness statements.
Sir, if you could answer the question, you can answer yes or no.
In part. In part.
Okay. And you believe the statements of your client, Linda Stermer, correct?
That she was downstairs and
No, I'm not asking you for a recitation, sir. I'm asking you if you believe the statements of your client that you've reviewed.
If you let the man answer, he's answering the question. You can't cut the witness off.
You can re-ask the question.
Thank you. You believe the statements of your client, Linda Stermer, correct?
In part.
In part. Now, you reviewed where she said that she came up the stairs, correct?
Yes.
And you reviewed where she described that the fire extended from the master bedroom to the Todd's recliner chair, correct?
That's what she said.
And you reviewed would have been the diagram she would have drawn then in her examination under oath, correct?
I'm not sure about who drew what diagrams, but if she did one under oath, I mean with Mr. Willison, I probably have reviewed it, but there were other diagrams that were made rough by a lot of people, so I can't really say which ones.
And you also would have read in her statement that she said it wasn't the fireplace, correct?
That's what she said.
And she indicated in her statement that there was no fire anywhere near the fireplace, correct?
That's what she said.
And that's an eyewitness statement, correct?
It's an eyewitness statement that you take at face value sometimes, and sometimes you don't. She's not a fire expert, so she wouldn't know what my thought process might have been.
Witness statements at face value. Let's talk about that since you brought that up. You brought up Mike and Connie Calhoun and Dr. Musali, correct?
Yes.
Now, you were a police officer for a period of time, correct?
I was a fire investigator lieutenant who had police powers. I carried a police badge from the Detroit Fire Department and the Detroit Police Department. I carried 2 badges.
And you, so you conducted interviews of witnesses then, correct?
All the time.
All the time. And you would agree with me that witnesses don't necessarily remember all details, correct?
That's one of the reasons you take it. And if it fits the patterns or the things that you know to be true with the physical evidence, that's how you differentiate one from the other.
Because based on your experience as an investigator and interviewing witnesses, sometimes the stress of an event can affect how they perceive things. Is that correct?
Absolutely, yes.
And it can affect the details they might remember, correct?
Yes.
Now let's cycle back to this chimney chase as the area of origin if we can. You indicated, I believe, that a fire would start in the chimney chase from either, I think you said the flue, or possibly an improperly connected chimney pipe. Is that fair? I'm summarizing, I understand.
Yeah, well, if I can explain a little bit.
Sure.
The description given by Mr. Leroy would fit almost exactly in part with what I would say. There is a breach somehow within the connections, or I think he described it as a hole. That could happen too, depending on the material that was being used and eroded through the course of time. Those kinds of things are a potential. I also said on direct, I believe, that there might be insulation too close to. The too close to the chimney chase can cause a fire over time. The fact that something escapes from the flue vent. And it's not that it was improperly, I guess maybe that's why I took exception to the improperly installed. It might have been properly installed, but because buildings shift and move and do things like that, I don't know how well those things were put together with a band to hold them, non-combustible band to the sides, which are combustible. So there's a variety of reasons why, that would happen. I think Mr. Leroy explained it very well, and he eliminated it because he said it would, wherever it happened, it would go up from that point to the top and burn everything out. Well, you've got a confined space, and heat is convected and radiated in that chamber also, and I know it's very possible that there was only OSB, from what I understand, on that wall. And so as that's being eroded or destroyed by the fire, it now is weakening the OSB, which is on fire, and that could have fallen into the living room and been the room of origin. Nothing going the other direction shows any sign, and Mr. Leroy very much covered that.
So you obviously, it sounds like you agree with some of the findings of Scott Leroy, is that correct?
Yes, absolutely.
Now, but you only seem to disagree with those that ultimately lead to this being an intentionally set fire.
No, I can't even say it wasn't intentionally set. In fact, I've testified in federal court to say I can't say it was not intentionally set. I said that the way that the investigators said this fire occurred is impossible to have happened. That's what I said.
And you've actually previously testified in this, right?
Yes, I just said in federal court, yes.
And you actually indicated at that time that it didn't look like it was a fireplace malfunction, correct?
At that time, I didn't have aerial photographs, and I didn't have a lot of the other photographs back in 2018 when that took place. 7 years hence, I have a lot more stuff.
What new stuff do you have?
New photographs, more photographs that I didn't have. I mean, they're not new today. They're new from 2018 when I testified. Now they're more new. And I'm not saying it was a chimney fire either. I'm telling you, we agree that there was something substantive in that chimney that needed to be looked at and needed to be eliminated. And my point is, we can't eliminate it.
Well, let me ask you some questions about this.
Sure.
Chimney chases, for lack of a better words, are like a long, tall box that's built around the pipes that go up through the roof. Is that kind of a
right? In modern day times, yes. As I think Mr. Leroy also explained how the old chimneys were, brick
Correct.
and all that.
And we're dealing with a modern
yes,
setup
absolutely,
here.
absolutely. So that's how it's built.
And the purpose of that is also to kind of keep if there is a fire, keep that fire kind of contained in one area. Is that correct?
It's supposed to. In this particular case, however, this chimney chase was built directly in the middle of the house. Most chimney chases are on the outside walls, so that's why I was able to tell causes of these things, because they were severely damaged and the remainder of the house wasn't, so we were able to conduct an examination that was enough to prove what happened, and I think there was...
Well, you're not, hold on, you're not proving what happened here, correct?
No. I'm just explaining that you're right. It's supposed to be, it is in a confined area, but it is not, in most cases, there are no fire-resistant materials in the chimney chase.
Fair. Now, as this, according to you, as we're describing this hypothetical chimney chase fire,
yes,
materials are going to be actually falling down on top of the fireplace like Mr. Leroy described, correct?
Yes.
And as a matter of fact, then, those are going to start to catch and burn not only the wall studs behind the fireplace, but also the header above the fireplace, correct?
You're speaking of the header that holds the fireplace in place?
Yes.
No, that's pretty well protected. That's on the outside. It's not even anywhere near where the grate and the fire is being propagated and goes up a chimney on an angle. It's called a throat. I had a diagram of one and how it's assembled. So, well, go ahead.
Let me ask it this way. Maybe I'm not being clear in my question. You saw the photograph that was up on the screen that was put up on one of Mr. Leroy's photographs showing the fireplace, correct? The first floor fireplace.
Yes.
And it had a wood header that went all the way around it, correct?
Header goes just above it.
Above it, I'm sorry. And there was framing around it as well still, correct?
I don't remember if I saw framing around the fireplace. I did see vertical studs going above the header.
And those are part of the chimney chase, correct?
They are.
And if a fire started in the chimney chase, the fire would then burn all of the fuel in that area, correct?
If it was not extinguished first, yes.
And we don't have it all burned in that area then, do we, sir?
We have a lot of damage, yes. By the fall down, there is certainly a lot of burning, but it did not consume what you're talking about.
So that would be an indicator then that it did not start in the chimney chase.
No, that header is on the outside. You're not looking at the interior, what was exposed eventually by the fire in the chimney chase or wherever in the building. Forgetting where it was a chimney chase or not, that header was protected. You have everything else in that room, first floor and second floor level, burned to a great degree. Much mass loss, as it was described by Mr. Leroy. Not about the chimney chase, but about how we describe things. Mass loss is the new word to say all the time rather than heavily charred. But in losing, okay, so what I'm saying is that particular board isn't burned and everything else is because it was protected.
Well, let me ask this, because it runs along the top of the fireplace, correct?
On the outside, yes. I mean, it's the outside base of what you're talking about to hold it together.
Okay. Can I pull up my exhibit, Your Honor?
Yeah, it's pretty empty here. You were so thoughtful.
Bring out the pictures. Huh. I think what he's going to do here is say that, yes, that board was protected from the living room side, but it was unprotected from the fireplace
This photo
side.
right here, sir. This is People's Exhibit 34-19. You've seen this before?
I'm sure I have, yes.
Okay. And that's the fireplace we're talking about, right?
Yes.
And that runs directly along the top of the fireplace, correct? That header?
Just like we said, yes.
Yep. And there's a backside to that board, correct?
Yes.
And that would have burned, correct? If fire had fallen on top of that fireplace?
You don't think the backside's burned?
I don't know. You're asking me a question, sir.
I am, because you're asking me and you're showing a picture showing the front. And certainly, I think I've seen aerial views that show that backside heavily charred.
But it's not burned all the way through, is it?
It's a pretty thick piece of wood, and it's not burned all the way through, correct?
Because if fire was burning in the chimney chase, when it lands on top of that fireplace, it's going to burn all the way through that board, isn't it?
No. It could, but normally, no. The fire's happening above, and you look at what the damage is above there, where OSB wood is no longer, and that would have fallen into the living room. That's the living room side.
But
this
the
side.
Burning debris within the chimney chase would have fallen on top of that fireplace, correct?
Some would, for sure.
And then it would have ignited that board, correct?
Probably not. It did ignite if you look on the opposite side. If we show the opposite side, that board is heavily charred.
What I'm trying to get to is, sir, that board would have completely burned then.
And I would say you're absolutely wrong.
Oh, okay.
It might, but not in this condition.
But not in this condition? Here comes the magic again.
You were asked about a little bit about gasoline, so I'll ask you the same question. And just so we lay a proper foundation, the vapors of gasoline are what burn, correct?
Correct.
And you would agree with me that if I were to, for instance, even in this room, pour gasoline here on the floor possibly, and put a candle over there, that those vapors could ignite, correct?
If the vapors got as high as the candle's flame, yes.
Okay. And in this case, we have a fireplace that's fairly close to ground level, fair?
Fairly close. You see that there's a bottom framing of that. So I mean, I can't tell from the picture, but 6 inches to 12 inches maybe. I could be wrong, but that's what it looks like to me.
Koberger's live on Top Mark.
And it is possible, is it not, to deposit an accelerant in a room, leave an open source of flame in a room, and leave that room, and the fire still ignite, correct?
You're asking me a hypothetical, right?
Yes, sir.
Okay, because I'm going to tell you about it depends. But yes, it could, depending.
And there are factors that depend on that, but it could happen, correct?
Could happen, but it depends.
Understand. It depends on probably, let me guess, the amount of gasoline and the type of ignition source, various factors, correct?
I'm just going to object here. We're asking questions, giving hypotheticals that have no basis in the evidence in this case. Zero. And it has to be based on evidence in the case.
I think it is, and I'll overrule.
Okay. So Waiting for a question.
Did you get, do you want to?
I think he
you
answered
said
the question,
depends.
yeah.
You said yes, depends, so.
Yeah, he did, and that's fine.
Okay.
And you heard, and we already kind of went over this, Ms. Stermer's statements about the fire going from Todd's recliner to the master bedroom, correct?
I don't know if she said it was going. I mean, that was the depth and breadth of the fire, I guess. When you say going, it seems like you're suggesting it went from here to there.
That is what I'm at. The fire, she described a trail of fire going from the master bedroom or to his recliner or vice versa.
I guess I still don't understand. Are you saying she saw this trail here and then go there, or just saw this?
Just saw a one continuous trail. How's that?
Wide range, yes.
Yes. In your expert opinion, that could be an accelerant trail, could it not?
Oh, I don't think anything she described would have been anything like a trail unless, as I said, if you're telling me you saw it go from here to here to here, that would be a trailer. But if you see an immense amount of fire going from a chair and including your husband and a wall, that doesn't tell me anything, except there was a fire in a wide area.
Let's talk about your the first video of the burning of the storage room. Is that right?
Yes, it was a storage room for a party store.
And that was actually a fire designed to replicate other fire you were investigating?
Yes.
And we saw lots of cardboard boxes in that video. Is that correct?
Yes.
And they were started on the floor, correct?
Yes.
And then they were actually stacked up to the ceiling, correct? Or close?
Close, yes.
Close to the ceiling.
Yes.
Fair. And then there was also a shelf along the ceiling with more cardboard boxes on there, correct?
Yes, they were, yeah, just yes.
And that fire, those cardboard boxes are fuel, correct?
Yes.
And would you agree with me, and I understand this is a layman's way to describe it, but cardboard boxes are fairly easy to set on fire.
I was going to give an example what was on the top. They are not easily ignitable up on top. And cardboard, it all depends, I guess, again, but those cardboard boxes, you saw how long it took for the sides to burn and how long it took them to actually become involved in the fire. So they will readily ignite, but not in a fast format or the way they, I don't know what the word I wanted to use. But on the top, they're old, long neck boxes that carried 24 bottles of beer. They don't ignite very easily. They're very strong. They're more dense. They're more pressed together.
Well, you would agree with me, obviously, that cardboard burns much easier than, say, like a log of wood?
Absolutely. Okay. Absolutely.
And that fuel load that you created in that room was designed to direct the fire up to the ceiling, correct?
No, it was to simulate the conditions that were told me by the owner, and this was the third fire we did. We built that building 3 times because we believed this guy, but the evidence didn't look like, I mean, if we just took it at face value, we'd have said the guy set the fire. The third one came out almost identical to what he saw, like what Ms. Stermer may have seen, and how that fire progressed before the fire department arrived. That's what I was trying to do. I was trying to simulate and see if we could create something that made sense to us by what he told us. And he told us what the cardboard boxes were. He told us what was in the cardboard boxes and how he'd stacked them. And that's why we did it that way.
And you said these were 8-foot ceilings, correct?
Yes.
And at the very beginning of the video, it looks like there's a fire started in the cardboard box. Is that correct?
Yeah, that's correct.
What was used to start that?
A match.
A match. Any accelerant used?
No.
You would agree with me that accelerant could have increased the speed of that fire, correct?
In the incipient stages. You know, there's stages of fire under normal conditions. Nothing's normal when it's hostile, but say you light a fire in a fireplace. You're doing whatever you need to stack the wood up in a configuration, put paper under it to make it burn quickly. What happens with gasoline and fuels like that, I don't like the term ignitable liquids because you just told me earlier liquids don't burn. I was against that, and I tried to not get it to happen in NFPA 921. I like flammable, combustible, things that are defined by my background. But going back to what you're saying, yes, in the initial stages, that would have not just gone slowly. It would have blared up or flowed up quite quickly.
A sudden fire, correct?
Yeah, absolutely, yes.
And going back to the chimney fire, those fires generally tend to start slowly and build, correct?
Yes, you have to pyrolyze the wood that is, I shouldn't use that word, but you got to take the liquid out of a solid to make it gas, to make it burn. And when you do that, it takes time when you only got a small, say, not a spark, but a small ember that comes out. It takes time, and over time, some of that wood becomes more susceptible to ignition. That's, I guess, what a better way of saying it.
Sure. And like the old adage goes, there's usually, if there's smoke, there's fire. So we expect smoke before the fire, correct?
In most instances, yes.
And in a chimney fire, we would have, it would have been expected that there would have been some smoke before this erupts into a blaze, correct?
It would be correct, but the smoke would be going up and through the chimney. Up through the chase.
Well, you understand that this wasn't 100% complete construction, correct?
I do.
And so high likelihood there maybe were some cracks or some seams, correct?
Yes.
And so smoke could have escaped from those, correct?
Supposedly there was OSB, which is 1/2 inch thick, 5/8 inch thick, and it's porous, but it's stuck together. It's chipped wood and stuff held together by glue.
Well, and I guess what I'm trying to get at here, if I can, is you were asked questions about there being 2 able-bodied persons in the residence, correct?
Yes.
And that this was, the time of day was about 3:30 in the afternoon, correct? Maybe a little before.
Yeah, 3:30 I think was the fire call.
Fair. And you would agree with me then that if a person, that is not necessarily a factor for the cause of the fire, but is something that should be considered by a fire investigator. The idea that there are 2 able-bodied persons in the home and the time of day, correct?
Yes, it's good to know, but it doesn't give you any evidence of a fire origin or a fire cause unless those people told you that, and Ms. Stermer was the only one who said she saw this fire in that location. So that would be the only person. But the first call at 3:30 or 3:31, the guy said the fire's coming out behind the chimney.
Well, but what I'm trying to get at here, sir, is if this is a chimney fire is a slow starting fire, correct?
Correct.
And there's going to be smoke, correct?
And smoke and heat rise, yes.
You would expect then an able-bodied person in the home, especially during the daylight hours, to notice that, correct?
Your foundation, he's the one who's been making objections all morning yesterday.
What's the objection? Objection is foundation?
Yes.
Okay. Response?
I think as a fire expert and investigating all these fires he's talked about, I think he can opinion on this.
Okay, well, I guess I can give an explanation like a hot air balloon. It goes up because there's heat in the balloon to go up. Heat and smoke rise. There had a fireplace, or I had a fire in that chimney, which obviously is emitting smoke also, and that heat and smoke is going to rise. So unless those people were outside, they were only going to see it coming through the chimney flue, or what they thought was the chimney flue. It wouldn't be coming into the house.
But as the fire debris begins to fall down with inside the chimney chase, they're going to notice it then, wouldn't they?
Chimney chase is still enclosed as far as the fireplace hearth is all enclosed. So there's going to be no indication of that until the fire breaks through that wall. And I'm saying, based on our hypotheses between us, where it started is where it's going to be the most damage is going to go up from there. But that location is going to be where that wall is breached and other things are coming down at the same time that's being breached.
There's actually a sound that's associated with chimney fires, isn't that correct?
Crackling sound of fire, they got a fire in the fireplace. There could be a sound, there's going to be a sound, but whether you detect it or not, I don't know.
It's a roar.
Now, one other thing I wanted to point out, I'm going to circle back, I guess, to your video. I keep finding different avenues as I ask questions, I'm sorry.
That's okay.
Your video, the first one of the storage unit.
Yes.
That fire, you would agree with me, doesn't spread to the surrounding boxes for about 2.5 minutes, correct?
That's probably, about right. I mean, we both would watch the time and know for sure, but yeah, somewhere in that general time. It was not that quick and it wasn't that slow.
Were you actually inside the building?
Yes.
Okay, was that you filming?
No, my son was filming with another firefighter. These both were Detroit firefighters. They're both retired chiefs now.
My 6-year-old son.
Fair. So what I'm getting to is, you could have escaped that fire if you had to, correct?
Yes.
And would have escaped without injury, correct?
Yes, unless I would have stayed where you saw the film kind of being jingling around. That's when the heat was too hot for those guys who even had fire gear on.
But of course, for that to have happened, you would have had to have sat there and watched this fire overtake you in the matter of 3 minutes or so, is that correct?
Yeah, I mean, if you were able-bodied, you should be getting out.
And you were asked questions about gasoline in the area of origin, correct?
Yes.
And we know Todd Stermer had gasoline on his sweatpants, correct?
We know there was analysis from the chemist that said it was 85 to 95% evaporated gas.
Objection, Your Honor. I don't think the chemist ever said that about the sweatpants.
Facts, not evidence.
Fair. But again, you indicated there was, let's just go this way, there was gasoline on sweatpants, correct?
There was residue of vapors of gasoline. When you say gasoline, I think of liquid, but there was no liquid on his pants.
Fair. You don't know how much gasoline was ever on those sweatpants, correct?
No.
So when you say, when you throw 2 ounces on a pair of cut-off sweatpants on a video, you have no idea, that has no way bearing comparison on how much gasoline was on Mr. Stermer's sweatpants, correct?
In jury instruction, it was never intended to demonstrate that. He knows that.
I think that could be misleading, so I'll have you move on.
Fair. Let's talk about the sweatpants you have as an exemplar and the ones in the video. Those are those the same sweatpants you have there that were bought, that were on that video?
Yes.
Where were they purchased?
We bought 3 pair, and I preserved one, the gray one. We burned, that was gray, I think, too. And the reason they were cut off is I did probably 20 other different kinds of demonstrations with them that we didn't admit.
And those are not the same sweatpants that are that were on Mr. Stermer, correct?
Same objection, Your Honor. This is misleading. We have a jury instruction, and he knows that.
I think this is perfectly relevant, Your Honor.
I'll allow it.
They're not the same.
They're not. They're not the same manufacturer, correct?
I don't know. No, they can't be. Well, I shouldn't say they can't be. One was made in Vietnam, and the other one was made in China. These were made in China. Stermers were made in Vietnam.
And you can't tell us they're the same thickness, correct?
I guess we could compare them.
No, I'm asking you. As part of your experiment,
right now,
you didn't verify they're the same thickness, correct?
Well, I didn't have possession and never did have possession. I looked at the things with Mr. Zerzine.
But you had an opportunity to examine those sweatpants, correct?
I was able to examine them, and the attorney would not let me do one thing I wanted to do because she's saying it changed the evidence. Well,
you might be talking hearsay, so I'll have you stop.
Yes, I'm the one that.
Pardon?
I'm the one that was there doing it.
Okay, thank you, but I'll have you stop here.
Okay,
now.
all right.
Thank you. You can't verify that they're the same weave, correct?
I can't.
And as a matter of fact, when it comes to polyester materials, there are actually different chemical makeups of polyester, correct?
The word poly probably says it.
So when it comes to 100% polyester, some may be different. One pair of 100% polyester sweatpants may be different from a different pair of 100% polyester sweatpants, correct?
Yes. Yes.
And as far as affecting how things burn, you conducted that test out in the open, correct?
Correct.
They were not on a human analog such as commonly used are pigs?
Nope.
And they were open to the air, correct?
They were.
Pigs are commonly
And there
used.
was a breeze blowing actually that day, correct?
There was.
You can see, and that also feeds into a fire, correct?
Usually, yes.
So the level of oxygen is important here, correct?
I don't think there was a deficiency of oxygen where Mr. Stermer was and or in this fire, so I don't see the difference, but the oxygen is present.
I'm just going to renew the objection. He's talking about now differences in ventilation versus this versus the test. It wasn't to recreate anything, it was to illustrate principles. These days now getting into trying to compare circumstances.
I get your point, but I think it's relevant to the purpose that we stated to this jury as for the offering of the polyester, so I'm going to allow it.
Thank you. And again, these were out in the open, correct?
Yes.
They were not on a person, correct?
Correct.
And you would agree with me that if they're on a person, that could affect the level of oxygen that they're exposed to, correct?
Yeah, they're being exposed to more oxygen, interior and exterior. You're correct.
And as a matter of fact, that completely discounts any human interaction with the pants, correct?
Correct.
Because a human, if, for instance, lit on fire, might try to put that out with their hands, correct?
That would not be a bad idea.
So
Yeah,
as a matter
correct.
of fact, I guess what I'm trying to get at is your experiment, we'll call it, was done under the most ideal of conditions, correct?
No, I don't see it that way.
But it didn't take into account multiple variables that you needed to consider in this case, correct?
No.
You talked about Mr. Matheny's clothes, correct? You remember that?
Yes.
And transference, correct?
Yes.
And you were present for the testimony of Troy Ernst?
I think I was, I've heard it. I think I was on video too. I mean, at video, YouTube at the same time.
And you indicate, and you heard him testify that on the shirt of Mr. Matheny is where the lighter elements of gasoline were present, correct?
If the lighter elements of gasoline were present, I think you're misspeaking, but I can tell you then he would have the most. The gasoline would be most on his shirt.
Well, no, okay. You're not a chemist, correct?
Nope.
You're not a forensic scientist in the aspect of chemical analysis, correct?
No, but I understand lighter and medium and heavy. And when you say lighter, that has more gasoline still residue left than the other way around. I think you just misspoke, but that's okay.
All right, fair enough. What I'm trying to get at is you heard him say that it was more likely that the gasoline was transferred from the sweatpants, socks, and underwear of Todd Stermer to the shirt than vice versa. Correct?
I did hear that, yes.
Please.
Sure.
Judge says, step right up. Step right up. It's coming up to court. He has it backwards. The lighter particles of the gas off gas and leaves the heavier stuff remaining. So that's the way I heard
Right
it.
now, I'll have you report back to the jury room at 1:15, and please remember not to discuss the case with anyone, no social media, no research or investigation or media.
Okay, as they go to the background, there you might hear a little whispering in the background. That is the voice of Brian Koberger's attorney, who is currently making argument in Idaho.
We had
right
our motion
here.
to strike the death penalty.
We're gonna possibly portal over to you to let you watch the end of that. It has been spicy in BK. I know I've been trying to do 2 ears. We've got the cross examination of the fire investigator here for the defense that has had to backpedal and tread carefully in a couple different areas. And let's see, not that one. I want to go. Where are we? What are you guys looking at? Oh, you're looking at that. Okay.
Counsel, the jury's left. Any matters to address in our break?
No, Your Honor. No, Your Honor.
Anything, Mr. Mueller or Mr. Kelly? Okay, we'll be in recess.
I'm like 99% sure this is a lunch break. Like 99.9% sure. We're going to do a portal over to Top Market Media to let you watch as this hearing goes on. Let me give you, before you go, let me read you what you missed, okay? Because it's live. Let me turn down her sounds just a teensy bit. Okay. In the Brian Koberger hearing, the defense has asked the judge not to let the state call Brian a murderer. Judge, they're calling him a murderer. That's not fair. Okay. The judge will address that. They also say that they want the judge to issue an order that the parties have to follow the rules, like the rules of evidence and decorum and all that. The judge says, no, they're rules, and both are going to follow them. I'm not going to issue an order. I'm not going to issue a rule that says you have to follow the rules. That's not going to happen. They asked... the state stipulates to not use the term psychopath when talking about Brian. He said, we agree. We're going to refrain from doing that. Defense says there are over 13,000 photos, hundreds of hours of tape. The judge says, absent evidence of a diagnosis of psychopath, I'd at least jump around a little bit because the conversation did. Terms such as psychopath will not be used. But if there is a diagnosis, then of course we can bring those in. The state can use the term murder when speaking of charges. Just don't make the argument. And don't make the argument. Oh my goodness, judge says don't make any arguments outside of closings. I do not want to hear standing objections with argument encased in it, because he says objections should not include oral argument or the judge will shut you down. He says nothing gets him going more than people making argument during objections or outside of closings. As regarding inflammatory evidence, the judge says, I don't know how I can rule on what's inflammatory evidence until we see the evidence, right? That's going to be sort of like an in-the-moment thing. He says, everyone just follow the rules. The defense says, but there are graphic photos. And the judge says, well, the murders were graphic. Okay, whoever did this, you can't just hide the pictures from the jury because, it's really bad, Judge. It's like really bad. Of course it is. The judge says some photos are definitely going to come in. We may limit it due to it has a cumulative effect. We don't need 500 angles of a body that's been stabbed, right? 2 or 3 may suffice. So there may be some limits there. Objections should not include, that's the other thing. Each side must share with each other what photos they plan on showing the jury. Hopefully that can be sorted out beforehand and not in the moment. There's going to be no ordering the rules to be followed. They started talking about 404B evidence. This is weird, and this is probably worth going back and rewatching. But defense brought up the traffic stop, the speeding ticket that happened when he was in the white Hyundai Elantra and he was pulled over and wasn't wearing a seatbelt and had the argument with the police officer about why he didn't need my phone number. And I don't think seatbelts make you safer and all that. They say that is more probative than prejudicial. That's for 404B. They also talking about mislabeling evidence. The state is mislabeling this to say they're bringing it in as a prior bad act. And this got really confusing because, as the judge pointed out, the defense doesn't understand the law about prior bad acts. The judge says the defense doesn't understand it. And the defense says, but we are still holding that position. Like the Amazon receipts, the state is doing an end run to allow this prior bad act in. The prior bad act of buying a K-bar knife on Amazon. They're like, that's an end run. The state's going around this rule that you're not allowed to bring that in. And the judge is like, am I understanding you right? You're saying that relevant evidence pertinent to the crime is a prior bad act? And like, yep, and it shouldn't be allowed in. They have to prove that some other way. The judge is like, I think we have a disconnect between the law and what is and what you are thinking about prior bad acts. They say, well, also the traffic stop, the video brings in other acts. It's more than just it's more than probative. It says his presence in Moscow was confirmed that night. A visual of the car, the make, the model, the seatbelts saying that seatbelts don't make you safe. Him saying, "Why do you need my phone number?" Why people lie about wearing their seatbelts to police officers. The jury may draw other conclusions like that and not give about why he did not give his phone number on that August 21st, 2022 night. The problem is there's clear video of a car in this, as opposed to the other videos that are blurry. You're like, that's you can't bring that in. That's prejudicial. It's prejudicial. No, it's evidence. It's relevant evidence. It was so funny to hear this. This argument was crazy. They don't want the video in because the cars look similar, the white Hyundai Elantra. The judge says the argument doesn't track under 404B. It's prejudicial in that it doesn't help your case. Date of stop links up with the dates the state says Brian Koberger was near the scene. Judge says that makes it relevant, not prejudicial. The judge says you don't get to tell the state how to try their case. Defense asks the video be excluded in states that use some other method to prove identity, like just having the officer testify about the stop and the interaction instead of showing the video. The state says the defense doesn't understand the law. Incriminating evidence is not a basis for exclusion. Judge is concerned about prior bad activity at the traffic stop and concerned about the dialogue between the officer and BK. That's probably going to be excluded. And the defense wants the officer to testify and not play the video. The state is worried that the defense may say that the state is trying to kill Brian Koberger. And they say that's an emotional appeal. I don't want Brian Koberger's lawyer to stand up and say, you just want blood. You just want somebody to die for this, and you've chosen my client. And they're saying, judge says don't do that. The state wants the definition of immediate family member spelled out by the judge because Brian Koberger's family wants to be there. They all support him. None of them want to help the state. The state may list them on their witness list, but they have not been subpoenaed at this point. And with the rule of exclusion, depending on what the immediate family member is, some of these family members may not be able to sit in trial if they're on that list. So the state says we're not doing that. We're not calling someone on the witness list just to keep people out of trial. And that's about where we are, where we jump to. So I wanted to give you the background on that. All of this is up on Top Mark Media channel. Where the whole video will be available. They are still going on. As a matter of fact, I'm going to turn on the audio again so I can hear. They're still arguing things right there. So here's what we're going to do. We're going to go to lunch. We're going to send you over to Top Mark Media. When we come back, we'll come back with a Linda Stermer case after lunch. And it's going to be awesome. It's going to be good. Tonight, when you go home, please hug the people you love, smile at someone to make their day just a little bit better. And please stay safe. To go live again after lunch. We will portal you right now over to Top Mark Media. You will have Brian Koberger live hearing in your ears in just moments. I think we're set up. Here we go. Ready? It's going to be magical. It's going to be magical. As soon as I click the right button. All right, now we're ready.